be seated. Good morning, everyone. This is the case of the people of the state of Colorado versus James Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King. I don't see Ms. Brady, but
She's just outside.
she's outside. Okay. Ms. Higgs is here, Ms. Spengler and Ms. Nelson are also here, and then on behalf of the people, we have Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Stitch McGuire. We are outside the presence of the jury. Yesterday, there was a bench conference that I had. Actually, there were a couple of bench conferences related to the defendant's statements. And these were the statements related to August 2nd and August 4th, I believe, of 2012, while he was at the jail. I know one of them was with Mr. Edson. I can't remember who the other one was with, but Ms. Higgs, I think, was involved in at least one of them, and perhaps both. And the objection was as to hearsay, and the people argued that the statements were being introduced for the truth of the matter asserted. These were statements that had to do with apparently using a spoon, I believe it was, to try to see what was behind an electrical outlet. And then the other one had to do with some kind of hair gel bottle, is that right? And a light bulb. And I thought more about it last night, and I agree with the people that both are being introduced for the truth of the matter asserted, or were being introduced, I should say, for the truth of the matter asserted. In both cases, the statements are being introduced exactly for the truth of the content of the statement. That is to say, the defense was showing that this was the defendant's intent, that his intent was to see what was behind the electrical outlet, and in the other case, that his intent was to do something with the light bulb and this hair gel bottle. The defense wants to rely on that, I understand, to argue that this is evidence that the defendant was insane at the time of the commission of the act, but they were being introduced for their truth. Ms. Higgs, I think, argued a couple of exceptions, and I'm not sure whether she argued both with respect to both statements or not, but I know that she argued a couple of exceptions with respect to at least one of these statements. One exception was present sense impression, which is 803 subsection 1, and the other one was state of mind under I believe it's 803.3. Let me just double check. Yes, 803.3. And I think she was right. I think under 803.3, these fall within the exception to the state of mind exception of the hearsay rule, because in both cases, the statements are about the defendant's intent or plan. He was asked a question about why he was doing what he was doing, apparently, or what he was doing, and then he stated what his intent was or what his plan was. In one case, because apparently he was trying to find out what was behind the electrical outlet. In the other case, because actually I don't know what the purpose was in the other case, because I don't think that came out, at least not yesterday. And both of these statements actually may have come out already with experts. I know that there have been some questions along the lines of these two incidents or related to these two incidents. And I can't remember whether the statements actually came out or not, and I can't remember at which point in the trial they came out. Obviously, this is a lengthy trial, but I seem to recall both of these incidents being alluded to in the past. It may have been by the prosecution and it may have been by the defense, but regardless, I sustain the objections and I'm reversing those rulings. So I will let the defense introduce both of those statements if the defense wishes, either by recalling the same witness, or by calling a different witness, or through documentary evidence such as a jail log, or through an expert, or however else the defense wants to do it. But as I thought about it more and as I looked into the case law, I decided that Ms. Higgs was right, and I'm relying on People versus Glover, which I have cited in this trial multiple times, but it's cited at 2015 Westlaw. I believe it's 7953690, and specifically footnote 5 in that case. And then People versus Acosta, which is cited at 338 Pacific 3rd 472. That's a Colorado Court of Appeals case from 2014. All right, and I think those were the only two statements that I remember that I excluded yesterday. And what got me thinking about it more was a bench conference that we had toward the end of the day when we were talking about statements that the defendant made, I think during a different incident. I think it was during the November 2012 incident. And those statements came in. I admitted those statements, but I had excluded the two statements that I just referenced a moment ago. If there are any others that I excluded that I'm not remembering, I'll leave it to the defense to remind me and to let me know. But I believe those were the two that I excluded, at least as far as I'm remembering right now. Ms. Higgs had asked me to reserve ruling on the video recording that was taken at the hospital. And I don't know that these DVDs have been marked yet. Have these been marked as exhibits yet, Ms. Higgs?
No, sir, I don't believe they have.
All right. Do you want to talk about them now? I think you had asked me to allow you overnight to think about the people's hearsay objection.
Yes, please.
And just so that the record is clear, this is a video recording that appears to have been taken by an investigator from the public defender's office while the defendant is in the hospital. Is that right?
Yes, it is while he is in the hospital on November 19th of 2012.
Okay.
November 19th or 20th.
All right. And the objection that I think you wanted to wait to respond to was the hearsay objection.
Yes.
And I've had a chance to review the videotape. I reviewed only one copy of it. I reviewed the one that has the subheadings, but I did review it last night.
Thank you, Your Honor. And one of the things that I think the court mentioned yesterday was, or asked yesterday, was whether at least portion of that video was played during opening statement. And it was. I went back and reviewed that clip that was played, and for ease of discussion, Your Honor, I have a transcript of the entire video, so I can point to the court on the transcript the portions that were actually played during opening statement. I'm happy to approach with a copy of that.
Is it an official transcript or is it an unofficial transcript?
It's a certified transcript by our office.
Okay.
With a certificate.
All right.
And I have a copy for the people as well.
Great. Thank you. Thank you. Is this this is the transcript of the excerpt that was played?
This is a transcript of the entire video. It mirrors the subtitles that the court viewed on the video, but just for clarity of the record, I thought it important to be able to point out where on the transcript the clip from opening statement began, and that was on page 2, line 42, and it went through page 6, line 47, or line 37. I think that that's clearer for the court than pointing out the times on the video of the clip that was played. And I would note for the court, Your Honor, that the people had all of our opening exhibits prior to opening statement and made no objection to Mr. King playing that clip for the jury during opening statement. Also, initially, Your Honor, I will sort of let the court know what this information is being offered for, and I think there are two sort of, I guess, exceptions to the hearsay rule, although the first really isn't an exception to the hearsay rule. It's just that it's not hearsay, it's not offered for the truth, but to show mental state and mental health. For example, when Mr. Holmes is talking about seeing shadows and what the shadows are doing, it's not for the truth that there actually are shadows present, but rather for his state of mind. And it's to rebut the prosecution's claim and their suggestions that he has been exaggerating or inconsistent, not really mentally ill, and their implications that he is sort of making this up. I would also offer these statements under Colorado Rule of Evidence 8033. I mean, the court just referred to that exception to the hearsay rule, and it does include statements of mental feeling, pain, bodily health, all as part of that exception to the hearsay rule, and we believe that these statements do fall under that exception. The other issue that I'd like to make a record about is what the DA has done in their case, because this is to give the jury a full and fair understanding of Mr. Holmes' mental state at a particularly vulnerable and important time, which was directly after his psychotic break in November of 2012. I mean, the DA has cross-examined repeatedly about how it's important to have videotape. I would think that they would welcome additional actual videotape statements of the defendant to show, of Mr. Holmes, to show his demeanor, to show his state of mind, to shed light on his mental illness, and that is one of the things that this video does. It's relevant for the jury to see his demeanor just a few days after beginning antipsychotic medications. I think this is especially relevant in light of the 22 hours of video the prosecution was allowed to show over our objection, which all occurred with Dr. Reed years after he was on the antipsychotic medication. And in light of some of the doctors from Denver Health that talked about the effects of the antipsychotic medication sort of taking effect immediately, but the full effect would not be seen over time. And so this video of him just a few days after beginning the antipsychotic medication gives context and a jury a full picture of how the antipsychotic medications are beginning to take effect, but haven't reached that full effect that we see in the video with Dr. Reed years later. I would note that the prosecution has been allowed to introduce a number of videotapes of Mr. Holmes, aside from the videotape with Dr. Reed, which includes various stores that he went to prior to July 20th of 2012. It includes video with audio of his last lab presentation in May. It includes video and audio of his statements to police directly after his arrest on July 20th. They've also been allowed to introduce a number of statements of Mr. Holmes through the forms of emails, statements to teachers, statements to friends. They've introduced statements of Mr. Holmes through kites in the jail that include library requests, medical requests. Through all of this and throughout their cross-examination, particularly I would note of Dr. Woodcock, they've argued and implied that all this shows that he was sane, but not only that, but that he wasn't even mentally ill. They've implied that he's not even significantly mentally ill to this date. And this information is particularly relevant to rebut those assertions and insinuations. The prosecution has called into question Mr. Holmes' credibility, especially about discussing hallucinations with various doctors. I think this goes to rebut part of those allegations. It's fundamentally unfair to allow the prosecution sort of this open door to admit anything and everything they want to with regard to things that Mr. Holmes said, without allowing Mr. Holmes to put that in context and give the jury a full picture of what his mental health and mental state is like throughout all of these relevant periods of time. I think it also in particular gives context to Dr. Holland's testimony. If you will recall, he talked about Mr. Holmes sort of covering up with the sheets, and this is further context to that testimony. I will make all of my arguments under Mr. Holmes' right to fair trial and fundamental fairness under the 6th Amendment of the United States Constitution, Article 2, Section 16 of the Colorado Constitution, under Mr. Holmes' right to due process under the 5th and 14th Amendments of the United States Constitution, Article 2, Section 25 of the Colorado Constitution, Mr. Holmes' right to a fair and reliable sentencing hearing under the 8th Amendment to the United States Constitution, Article 2, Section 20 of the Colorado Constitution. I'd also argue it is relevant under Colorado Rules of Evidence 401 and 402, not hearsay under 801, and certainly a hearsay exception under Colorado Rule of Evidence 803, and his right to present a defense under both the United States and Colorado Constitutions.
All right, thank you. Who wants to respond?
Your Honor, it's immaterial whether they use this in their opening. We're not required to give an evidentiary objection to everything that someone uses in the opening. They still have to get it admitted during the case in chief. I mean, we gave them notice of everything we were going to use in opening, and they didn't object to them then, but they've lodged plenty of objections to that same evidence that's been offered during trial. So, and they had advance notice of all of that. So that, to me, is immaterial as to whether or not they can lay a proper foundation to admit any of this. Ms. Higgs seems to forget that what we entered of the defendant's statements is a well-established hearsay exception of admitting a defendant's statements by a party opponent. They are not a party opponent, so they do not have the advantage of that hearsay exception. They went and did an interview with the defendant that they want to admit without him being subject to cross-examination on any of those statements. And it certainly seems as though they're offering all of those statements for the truth of the matter asserted. This is simply not admissible under any of the hearsay exceptions, and I don't believe that it's admissible under 803.3 because a lot of this has nothing to do with his medical condition. They just want to get in a long interview of the defendant where we can't cross-examine the defendant on any of those statements, and that is not the same as us offering it as a party opponent, and they're offering it for the truth, and there's a lot of extraneous information in there about all of these. So the PD investigators are not his doctors, they are not treating him, so they don't need to establish his state of mind for the purpose of diagnosis and treatment. So I don't see how this is admissible in any way, shape, or form. If they want to show a video without any audio, I think they could do that, but I don't see how they are able to use the audio, and we absolutely would object to anything where they've added text to it as well.
All right, thank you. Well, I think that at least some of the statements in this, I think it's a 25-minute video, about a 25-minute video, so it's a lengthy video. At least some of the statements are being admitted for their truth. For example, statements about shadows, those are being admitted for the truth of the content. In other words, the defense wants to show that the defendant was talking about shadows, about seeing shadows under the blankets the night before. I understand that they want to rely on that to then argue about his mental illness, but they are being offered for the truth. So at least some of the statements in this interview are being offered for the truth of the matter asserted, and they are hearsay. At least, and then Ms. Higgs argued that one exception under the hearsay rule applies. The exception that she mentioned was state of mind. It's possible that there are statements in here that would fall within the state of mind exception, but certainly there are a bunch of statements in here that do not fall within the state of mind exception, 803.3. So that exception doesn't save the entire interview by any means. And I think Ms. Higgs at the end just mentioned 803 in general. I don't know what other exception the defense is relying on. The one they mentioned was state of mind, but I can't think of any exceptions under the hearsay rule that would allow the entire interview to be introduced. And this is about a 25-minute interview by an investigator of the public defender's office of the defendant while the defendant is in a hospital bed at Denver Health Medical Center in November of 2012. And it has sound. Generally speaking, you can understand what's being said. Every once in a while, there are things that are hard to understand, but clearly it's on audio. It's not just video without sound. It has sound, and you can hear not only the questions from the investigator, who's not a doctor, not a medical person, not a psychiatrist, and you can hear the answers the defendant is giving. It is interesting because in this case, we've had a lot of expert testimony, and the experts have relied on a lot of this material. And so a lot of this information has been alluded to already through the experts. And I don't know whether Dr. Gurr will testify about relying on this and whether this will be admissible under Rule 703. And if the defense wants to attempt to establish foundation through her under Rule 703, they can try that. But I think, given the record before me, I agree with the people that this is hearsay. And I understand the arguments Ms. Higgs is making in terms of what evidence the people have introduced. But the people have had to comply with the rules of evidence on every single evidentiary item that they have introduced. And that's because the rules apply. And there have been objections, and I've been ruling on the objections. I would not agree that there has been an open door policy that has allowed the people to introduce whatever they want. That there have been some things that I have not allowed them to introduce. And so they haven't introduced everything they've attempted to introduce. They've introduced what I have allowed based on the rules of evidence, or what the defense has not objected to, what the defense has decided that they don't want to object to, and they have strategic reasons for that. But certainly this particular interview contains hearsay, and and the hearsay exceptions, or the exceptions to the hearsay rule, do not apply to the to all the statements in the video. So the hearsay objection to the video is sustained. As I said, though, if the defense wants to establish foundation under Rule 703 or attempt to establish foundation, then they can attempt to do that. And I assume that this was sent to both Drs. Reed and Dr. Metzner, but maybe I shouldn't assume that. Were these videos sent to both of those doctors?
Yes, Your Honor, they were.
And, both doctors, I think, testified about the defendant's mental state around November 2012, presumably in part based on this video, and presumably in part on all the other records surrounding the November of 2012 incident. And so in a way, some of this has come out already, and the jury has heard about some of this, and presumably Dr. Gurr has relied on it too. But there's a certain foundation that you have to establish under Rule 703 for this to be admitted through that rule. So the defense can attempt to do that when Dr. Gurr testifies, or when any other expert testifies for that matter. Dr. Gurr comes to mind because she's the one that I would think may have relied on this, justifiably relied on this. And I'm not making any findings, I'm just saying it's possible. But if the defense lays the proper foundation under Rule 703, then I will readdress the issue at that point. Of course, the people will be allowed to respond to any request at that time as well, and we'll go from there, all right? So, Ms. Higgs, you may approach to retrieve the 2 discs.
Thank you. And the transcript?
Oh, and the transcript as well, thank you. Thank you, and thank you for providing the transcript. I appreciate that. I agree with Ms. Pearson on the opening statement, part of the argument that the parties have made, that just because the people did not object to part of this being played during openings doesn't mean that they are not bound to that decision and they cannot object at this time. I think in opening statements, the parties are presumed to proceed in good faith, and I don't think an opponent can just object and say, I'm going to object to that without knowing whether the proponent is going to be able to introduce it into evidence to lay the proper foundation. For example, it's possible that these statements can be introduced if the defendant testifies. It's possible that in that case that perhaps it might be a different story. I don't know. It's possible that it might come in through Rule 703. There are all kinds of different scenarios, and I don't think that just because the people did not object in opening statements that, or an opening statement that they now cannot object.
And
All right, Ms. Higgs?
yes, Your Honor, we would ask to mark these as court exhibits. Do we know what number we are on?
What number are we? 78? So you can mark them as 78 and 79.
I'm going to, just for the record, mark the video with text as 78. the video without text as 79 and the transcript as 80.
Okay,
And I will give those to the court later.
Great.
Thank you.
All right, are the parties ready for the jury?
Yeah, Your Honor.
Sorry. Hey, Your Honor, I wanted to follow up on this issue that was raised by Ms. Wheeler from the Attorney General's office. We did reach out to her yesterday, a couple different times. I don't, Tish, have we heard back? We have not yet heard back from her. However, we've gotten an email that was sent to me from Ms. Nelson to Ms. Wheeler indicating their objection to any use of the raw data, the answers to questions, or anything else other than just whatever the psychologist feels comfortable testifying to, and said that, I think in the email, and ma'am, if I'm misstating this, Ms. Nelson, you fix it. The gist of it was, hey, if Mr. Brockler is going to get into any individual questions, we're going to seek to publish the entire examination and all of its questions. I think that even without hearing from Ms. Wheeler, Judge, I think it's likely at this point that we're not going to reach some sort of consensus, and maybe it's appropriate to try to schedule a hearing in advance of those witnesses for the court to address that. I know from speaking with Mr. King this morning that he anticipates that Doctors Gray and Manguso, who are most likely the ones that would testify about these tests, specifically Dr. Gray, that they'll be testifying tomorrow at some point. And I know that creates a bit of an urgency issue, but it's where we find ourselves, Judge.
Well, it's whenever Ms. Wheeler is available. I'm here and you're here and they're here. The defense is here, but it's whenever Ms. Wheeler can get here. I'm happy to have a hearing, a short hearing about what the concerns are and what we can do. I mean, I'm sensitive to the concerns about copyrighted material, but I'm also sensitive to making sure the parties are given an opportunity to try their case. And so it's, it's a difficult thing. I mean, something's going to have to give, and that's why I was hoping that Ms. Wheeler could work with the parties to see whether there was some kind of agreement that could be reached that would allow you, Mr. Brockler, to inquire into the data underlying the test without perhaps jeopardizing some of the copyrighted material in the test.
Your Honor, I just got handed a note from Ms. Tish McGuire indicating that Ms. Wheeler just reached out to us and indicated she would talk with us today. Maybe we table this for the moment. We'll work with her on a resolution or a date that she can be available, a time that she can be available.
Okay, Mr. King?
And Judge, just for clarification, I think part of this turns on how this data is used and to what extent. And that's the reason that Ms. Nelson sent the email that she sent this morning after we got a chance to consider it. And just to give the court an inkling of what I'm talking about, there's a real difference between asking questions about the psychologist's interpretation of the data. For example, you overemphasize the K scale, or you misinterpreted or miscalculated the correct result from the testing that was given. That's a very different thing from going into the questions of the tests themselves and taking them out of context and inferring meaning from the individual questions, which is completely improper use of the material, and that is what would also jeopardize the copyright, because that's the actual test itself.
And so you're saying that if Mr. Brockler gets into some of the questions, then you're going to, at that point, be in a position where you think you'll want to introduce the entire test.
The MMPI, for example, Judge, is 567 true-false questions. It's many scales that are interrelated statistically, and the validity of the test comes from the statistical validation of the test taken all together as an entirety. If you take one question out, and many of the questions are extremely odd, for example, and if you take one of the questions out and attempt to infer meaning from the answer to that question, it's very misleading. and not reliable under any standard of admissibility under any court that I'm aware of. So that's kind of the distinction that we see here. I'm not speaking for Ms. Wheeler, obviously. She may have different concerns, but that's the concern we have. And the court is right. If the court were to allow Mr. Brockler to go in and individually select out the questions that he happens to like the answers to and present them to the jury out of context, it's very misleading to the jury, and it would put us in a position where we have to then go in and select the questions that we want and present those to the jury, and it becomes a misuse of the instrument, Judge. And so that's where I'm coming from at this point. And so in terms of when Dr. Gray is going to testify, I told Mr. Brockler this yesterday. When I told the court yesterday that he was scheduled for Thursday, I meant Wednesday. And that was because of the short week. I got confused. But I stand by what I said yesterday, that if we need to delay his testimony to resolve this issue, we can certainly do that, I think, given his schedule. So.
Okay, thank you. Mr. Brockler, at this time, you think you're going to get into some of the questions and answers of the test? Is that the data that you are referring to?
It is, Your Honor. And I would say, unless the court has another question, I mean, in part here, what we're suggesting through this argument is that the experts get to tell us how we value true-false responses to factual questions. I'll give the court one example. This MMPI-2 report is generated by computer software. This psychologist will say, I don't go in and add any language to it. It just prints out based on these answers. And one of the things it'll say in that report is that Mr. Holmes feels hopeless. Well, as it turns out, there's an actual question in there. True, false. The future seems hopeless to me. And he answered, false. Why shouldn't the jury be allowed to consider those kinds of discrepancies when it is a software package that determines the language of the actual report that's generated, and then psychologists interpret them? Now, Mr. King can certainly ask the psychologist to tell the jury, hey, it's not fair for you to consider true-false questions individually about factual things. But that's for them to decide. Psychologists don't get to come in here and tell us what the jury should be permitted to. You do, Judge, and they get to weigh those things. That's great stuff for direct or redirect, but it doesn't seem like it's the gatekeeper for a true-false question about a fact.
Is there a way to accomplish your goal without getting into the specific question? So, for example, I am assuming the jury is going to hear that one of the conclusions was that Mr. Holmes feels the future is hopeless. Is that what you're expecting?
That's what the report says, Your Honor, and I
Right.
presume the psychologist will testify about that.
All right. And can you then ask, isn't it true that there was a specific question asked about this topic, and that contradicts that conclusion? I mean, can you ask that without getting into the specific question?
I think I could ask that, Judge, but I think based on some of the other questions that are here, the word contradicts is a conclusion that they may disagree with. They may say, well, I don't think it contradicts it. I think because of this word, that question should be interpreted a different way, or in and of itself it shouldn't matter. And the issue is, should these folks be able to hear that he answered false, the future seems hopeless to me, when the conclusions of the software and the psychologist are, oh yeah, heavily depressed, he thinks the future is hopeless. And there's a number of examples like this in a bunch of different areas. I could go general. My concern is we're going to get there and the doctor is going to say, I don't agree that that answer is inconsistent.
And have you talked to Drs. Rose and Manguso about this?
Dr. Manguso, I'm hopeful of talking to her before she takes the stand tomorrow, Your Honor. We're trying to effort that.
Okay.
Well,
Mr.
Judge,
King.
Dr. Manguso didn't administer these instruments, so I don't expect that she would testify about them.
Dr. Gray, I meant.
Dr.
Gray,
Gray's
yeah.
the person that administered these instruments. I have discussed this with him, and he indicated this would be a misuse, a gross misuse of these tests. And the example that counsel is giving of the juror being able to interpret the answer to a specific question is exactly the problem. That is exactly what is a improper misuse of this testing data, and it's very dangerous and very misleading. That's what psychologists would testify to. So I think I wanted to give the court an idea of where I was coming from. I think we may be getting a little ahead of ourselves here.
Right.
And we would ask for a hearing before any of this was actually admitted and a chance to present evidence.
All right. I think I said Dr. Rose and Manguso. I meant Dr. Gray and Dr. Manguso. But let's see if Ms. Wheeler can come here, and I think it would be helpful to have Dr. Gray present as well, because he may shed some lights on some light on this.
Understood, Your Honor.
So,
We'll work with Ms. Wheeler. I presume Dr. Gray, being the defense's witness, they probably have a pipeline to him to get him here.
well, he can be here if he can be here today, this afternoon, at the end of the day, then, we can take it up at the end of the day today. If not, we'll do it tomorrow. But it would probably be helpful to have him present while we're discussing this particular issue.
Yes, Your Honor.
Okay. All right, by the way, before I bring the jury in, with respect to Exhibit C-TR-78 and C-TR-79, I just want to make clear that my ruling was based on the exhibit that was submitted to the court. In other words, the interview in its entirety. I'm not ruling on any redacted or edited version of it without sound, or any redacted or edited version that would cut out some statements. It was tendered to me, and I was informed the defense wished to introduce the interview in its entirety. In its entirety, my ruling is it contains hearsay and at least portions of it, and therefore it cannot be admitted. All right, are the parties ready for the jury at this time? The people? The defense? Ms. Nelson?
Your Honor, I have two brief instructional issues that I wanted to discuss with the court.
Yes.
The first was just the court made some comments yesterday about the potential inconsistencies of when we've requested the limiting instruction be given about the jury's consideration of certain evidence solely for the purposes of sanity.
Right.
I just wanted to give the court, I gave it some thought last night, and I just wanted to let the court know where we're coming from and what our position is on the limiting instruction, just so that we're all on the same page. I went back and looked at motion D-276, which is the motion in which we requested that the court give this limiting instruction. And really the basis and the origin for that limiting instruction is section 16.8.107.1.5a, which talks about the limited purpose for which information, including communications derived from a court-ordered examination, as well as communications derived from the waiver provision of 103.6, the limitations placed on those, that information. And the purpose, obviously, behind that is to protect a defendant's right to self-incrimination. And so that's the reason in the statute that there's a specific legal reason why that evidence derived from those two statutory provisions can only be admitted as to sanity and not as to any other purpose, such as the defendant's guilt. It's to protect the defendant's Fifth Amendment right. So in our view, I think the limiting instruction applies obviously to anything that comes out or came out about Dr. Reed's examination, Dr. Metzner's examination, which the court instructed the jury properly, as well as, pardon me?
The notebook.
The notebook, and then all medical information that was disclosed as a result of the waiver provision of 103.6. So testimony from medical doctors who examined him, our experts, etc. So all of those situations are appropriate. All that testimony is appropriate. The limiting instruction is necessary and appropriate. And I think, if I'm recalling correctly, that the court inquired whether we wanted the limiting instruction to be given with respect to some of the testimony coming from the jail deputies, if I'm remembering correctly. And I think that's different because there's no legal reason to restrict the jury's consideration of that evidence. Now, it may be that the jury doesn't think that evidence is relevant except to the issue of sanity. However, I don't think that it's appropriate to give the jury a that particular limiting instruction, because there's nothing in the statute, there's no legal restriction on the jury's consideration of that evidence. And in fact, as we had a discussion during the charging conference last week, perhaps they want to consider it as part of a Hendershot Van Rees type defense of whether in fact he did form the culpable mental state, not whether he was capable of forming the culpable mental state under Part B insanity. So that's our position as to when the limiting instruction is appropriate to be, or should be given, and when it should not be given. Does that make sense?
Yeah, it makes sense, and I agree with you in terms of the legal basis for the instruction. And I think I've given it pursuant to the law in the circumstances that you've mentioned. I've given it in a couple of other cases or a few other circumstances at your request or at the people's request without your objection. So, from here on out, if either side wants me to give the instruction, then it's gonna be on you to ask for it. And I'm gonna put it aside and not give it and not ask you about it. And I'll only give it if either party thinks I should give it. And if there's a disagreement, then I'll resolve that disagreement here at the bench. Does that make sense?
Yes.
But so far, I've given it when either both sides have asked for it or when one side has asked for it without the objection of the other side. And so it's been given generally, I think, as Ms. Nelson indicated, when Dr. Reed testified, when Dr. Metzner testified, with respect to the notebook, it was given. It was also given with respect to Dr. Fenton, with respect to Dr. Feinstein, and then in a few other occasions that either the defense has asked me to give it in, or with respect to, or the people have asked me to give it with respect to, without objection from the defense. So, but I appreciate you reacting to the what I was wondering about yesterday, and it makes sense, and so we'll just do it that way, okay?
Thank you, Your Honor.
So the parties are both on notice, that's how we will proceed. What about the proposed instruction based on Mr. King's request?
Yes, that was my second item. I made I would like to suggest just a couple of modifications to
Yes.
the court's proposed instruction.
Yes.
We're fine with the first paragraph. Our proposal would be to omit the first sentence of the second paragraph, and I can tell the court, my only concern is just conveying to the jurors that there may be a fine line in terms of what they can use and what they can't use. I think the instructions to the jurors should be, while there may be a fine line, legally speaking, and a fine line for the lawyers in the court to sort out, in terms of conveying that to the jury, that might just confuse them in terms of, well, when can I and when can't I? So my proposal would be to omit that first sentence of the second paragraph. And then the other proposal, and this is also taken directly from the Kendrick versus Pippin case that the court relied on as well. I just wanted to add something to the last sentence of the second paragraph, stating, while a juror may use, so the addition would be, and I typed out a revised copy of this that might be easier for me to just submit it in writing to the court. But I can tell you that I'd like to add, while a juror may use her personal experience or knowledge where that knowledge is relevant to the matter at hand, a juror may not introduce extra facts or law from an outside source that are not part of the evidence in the trial. Or I guess it would be that is not part of evidence in the trial. Would the court like a written copy
That's
of my
okay.
revisions?
No, that's okay. Okay, I agree with your suggestion with respect to the second paragraph and specifically the first sentence. I didn't like that sentence anyway, so I completely agree with you. And I don't have a problem with your last sentence. It's frankly a little repetitive in my view, and I don't know that it's necessary, but I don't have a problem with it. Do the people have a position?
I was about to say it's somewhat repetitive, but,
Well, now you're being somewhat repetitive.
yeah. Well, that's probably the correct assessment, Your Honor. I think that I think it would actually read less repetitive and more clear if we just got rid of that first sentence in the second paragraph, because I don't think that the additional language proposed by council really adds anything that isn't there already. So that, I don't have an objection. In fact, I think it's a good idea to get rid of that first sentence in the second paragraph, but I think once that's done, the instruction's fine as it is.
How about this, Your Honor? What if we just added to the first sentence, jurors are allowed to use their background, including their professional and educational experiences, when that background is relevant to the matter at hand to inform their deliberations, or just, that's the only part that that proposal that I made in the last sentence adds. It's just, when it's relevant to the matter. That's really all I care about. Sort of states the obvious, but I think it's better to have that in there.
But you still want to inform their deliberations?
Yes, yes.
Okay. So it would read, jurors are allowed to use their background, including their professional and educational experiences, when that background is relevant to the matter at hand, to inform their deliberations, so long as they do not bring in specific factual information learned from an outside source. I'm not crazy about when that background is relevant to the matter at hand to inform their deliberations.
Your Honor, if I may?
Yeah.
I agree with what Your Honor just said. To me, that is going to impose a very confusing limitation on the jurors' ability to use their background and experience and so forth. We tell jurors to use their life experience and their common sense when they come in, and we don't explain to them there are certain parts of your background, life experience, that you can use and certain that you can't. It can be all kinds of things that inform a person's understanding of the world and common sense that can be used in their analysis as a juror. And to try to put a limitation on that by having them sort of act as a judge and make a 403 analysis as to whether it's relevant, or a 401 analysis, and without even really telling them what relevance means and how they're supposed to make that decision, I think could be very confusing.
Well,
And Your Honor, it's lifted directly from that Kendrick case, but I understand what Mr. Orman's saying. I leave it to the court's discretion.
I just don't like that phrase. I don't like the word relevant in there. I don't like the matter at hand. Matter at hand are things that lawyers use, but not necessarily lay people. That's not how regular, normal people speak. So I think I'm just going to leave it the way it is in terms of the first sentence, Ms. Nelson, and then but I will, that's the first sentence of the whole instruction, but I will take out the first sentence of the second paragraph, the way you've asked me to do. And I don't think the last sentence adds anything, and so I'm not gonna add that sentence. But I'm happy to give the instruction. Do you want me to give it today, or, and do you want me to tell them why I'm giving the instruction? In other words, do you prefer that I say something like, members of the jury, a couple of you have submitted questions that reveal that you have some medical background, or you may have medical background. Let me give you an instruction at this time, or do you want me to just give the instruction?
I think just give the instruction, Your Honor, and yes, I think we'd like it today.
Okay. Any objection from the people to me giving it today?
I don't object to that, Your Honor.
All right, I'll give it this morning when they come in, when the jury comes in. All right, are we ready for the jury now? Yes? Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect the jury is in the courtroom now. Good morning, everyone. How's everyone doing? Everybody doing okay? Great. Thank you for your patience with us this morning. As you know, there are times when the lawyers and I have to talk about legal issues or administrative issues or scheduling issues or perhaps more than one of the above. And we have to do that outside your presence. But I very much appreciate your indulgence. Before we start this morning, I have an instruction that I'm going to give you. It reads as follows. Jurors are allowed to use their background, including their professional and educational experiences, to inform their deliberations, so long as they do not bring in specific factual information learned from an outside source. Any experience, used by a juror in deliberations must be a part of the juror's background, gained before the juror was selected to participate in the trial, and not as a result of an independent investigation conducted after being selected as a juror. Additionally, a juror may not introduce specific facts from an outside source that are not part of the evidence in the trial. Does everyone understand that? And everyone's saying yes and nodding their head yes. And I gave some of you a similar instruction, a few of you, during individual jury selection, if I remember correctly. But some of you may not have heard it, and the instruction that I gave earlier may not have been as complete as the one that I just gave, okay? All right, with that, we'll proceed. Would the defense please call its next witness?
Your Honor, the defense would call Sandra Pagan.
Good morning. Could I have you raise your right hand for me, please? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, please be seated. Please tell us your full name and spell your first, middle, and last names.
Sandra K. Pagan, Sandra Kay, Paggen.
Can you move the microphone closer to you, please? You're soft-spoken, and we want to make sure that we can all hear you, okay? All right, Mr. King, you may proceed.
Thank you, Your Honor. And thank you, Ms. Pagan, for coming in. You've been very patient with us. The microphone will actually slide right closer to you if you pull it.
Oh.
There you go. Can you please tell us, are you employed now or not?
No, I'm retired now.
Okay. And what did you do before you retired?
I was working at Arapahoe County Jail as a day nurse,
Okay.
RN physician in the infirmary.
And did you just say you were an RN?
RN.
Okay. And what were your responsibilities, just generally speaking, as a nurse who worked in the detention facility here?
My primary one in the infirmary was taking care of and monitoring the inmates that were in the specialty units.
Okay.
Medication.
Giving them their meds and checking on them to see whether they were doing all right?
Mm-hmm.
And I
Yes.
imagine that can be a busy job, fair to say?
Yes.
Were you working there during November of 2012 in that capacity?
Yes, I was.
And do you recognize Mr. Holmes, who's seated over here?
Yes.
And was he housed in that unit at that point in time?
Yes, he was.
When you spoke with Mr. Holmes, well, first of all, did you speak with Mr. Holmes at times, just in
Yes.
passing? And what was your interaction with him? Did he talk back to you?
Yes, oftentimes he would just simply say, "I'm fine."
Okay.
Ma'am, I'm sorry, you're soft-spoken.
Oh,
Can you move the microphone closer to you? Just
Yes.
The microphone moves, so you can move it.
I thought,
Just move the whole thing. There you
Okay.
go. Thank you.
what I'd like to do, did there come a time when there was a change in behaviors that you noticed Mr. Holmes engaging in somewhere around November of 2012?
The middle of November.
Okay. And I've got here a copy of the notes from the medical facility in the jail, including your notes, if I can approach Judge just in case she needs to refresh her recollection with this.
Yes.
And I don't know if you've had a chance to review any of those before your testimony here today, ma'am, but if you need to, you can feel free to take a look at that. I put a little blue sticky on around the 11th or 12th of November there. Well, first of all, those notes that you're looking at, what's the purpose of taking notes like that?
We documented every day during our shift, general behavior, any, changing of behavior,
Okay.
and to make sure that it was documented that he had done what we called activities daily living, that he was up, showered, took care of himself, had a meal.
And is that part of your responsibilities in taking
Yes.
care of these folks? And I assume you would do the same for anyone else who was in there.
Everybody.
I want to first take a look at, if we could, your note from November 11th. Was that about when things changed a little bit?
Yes.
Tell us generally what happened. What took place that caught your attention, or did you notice about Mr. Holmes during this period of time?
What I would say is his activity became a little more physical. He was usually he just laid in bed and rested, and he would get up and exercise at times. But it just seemed he was exercising on getting up and doing push-ups and jumping jacks and exercising. He just became a little more active.
Okay. And do you see the note there from November 11th at 12:22?
Yes.
Was he moved to a suicide room or cell on that date?
I think he's still in medical on this date, on the medical side.
Okay, okay. Was he given a suicide mat then, that date?
Looks like he was. Looks like the deputies gave him a suicide mat.
Okay, what does that mean?
That means that he's being protected so he doesn't hurt himself.
Okay. Did he have anything else on at that point in time other than that suicide map? Can you see in that note there?
Yeah. Looks like he's been moved in the evening to BC5, which is the behavioral unit.
Oh, and
And
that's
when they go in the BC side, that means they have to have a suicide mat to sit on the floor. If they don't have one, then we try and get them one.
okay. And other than that, would the person have any other clothing or not?
They are given clothing.
Okay.
Sometimes they don't keep it on, or they're not given clothing. I think he was given some clothing, and he sat on his clothing.
Okay. Do you see there in that note whether or not Mr. Holmes ate any food, ate at breakfast or lunch that day?
According to this, he ate the breakfast, but the lunch sack was still there at
Okay.
the end of the day when I charted.
Great. Thank you. If you could now take a look at the next day, which is November 12th, and I think your note is at 10:33 in the morning.
Yes.
Now, did he come to the door to get breakfast, the door of the cell to get breakfast that morning at 10:33?
No.
What did you observe him to do at that point?
He was laying like in a frozen position on the floor, on his stomach.
Okay. Can
And
you
he-
describe a little bit more what that looked like?
On his stomach with his arms twisted up like this, and his feet and his legs with his legs bent up in the air, just kind of
Okay.
his legs up,
So he's
His
laying on his
arms-
back or his stomach?
stomach.
laying on his stomach and his arms are twisted out behind him
Out
like I'm
behind
doing
him.
right now?
And his legs up, kind of, and he was like frozen. He wouldn't move. Tried to move him and he was stuck.
Okay, he was stuck. Was, did he, did you observe what he did with the suicide sack breakfast that he was given?
Yes, he was in this position and turned face, and he was trying to like reach for or motioning towards the sack with his mouth, like he was like trying to reach for it to get it, but he couldn't reach it. It was just really odd watching it.
Okay. And was he naked at that point, or
I'm thinking he's naked, yes.
what other behaviors did you notice that he was doing there?
On the video, we watched him take the, because we're watching him. 'Cause
Okay.
he's not, acting okay. And that he gets unstuck, but he sticks the sack and he puts it down the grate. There's a grate in the middle of the floor
Okay.
that's used for toileting and garbage.
So he put the sack down the grate? What else did you see him doing during that period of time around mid-morning on the 12th of November?
Okay, we watched him on the video licking the walls.
Okay.
And then he would get up and just keep constantly rearranging his clothing on the floor. Just restless behavior. That's what I described it as. He just looked restless.
And did you try to communicate with him that day? Was he able, or did he communicate back to you when you tried to talk to him?
No, he did not. I mean, I tried to communicate, but he wouldn't answer.
All right. I think the next note is on the same day, November 12th, 2012 at 13:25. Would that be 1:25 p.m.?
Yes.
And again, is there any indication about whether he is able or willing to communicate with you at that point?
He's not able to communicate.
What do you mean by odd eye contact? Do you remember?
Yeah,
It was a long time ago.
yeah, just a blank stare, like
Uh-huh.
he'd just look at you and be looking right through you. Just no connection,
As if you weren't there? Or?
as if it wasn't there. Yeah, he'd just be looking straight. But he would look, but it was
Okay. And
connection look.
are you demonstrating that look
Yes.
for us? Does your note from 1:25 that day indicate whether he continued to do odd behaviors that afternoon?
Yes, he did. When it was lunchtime, I was there when he was, and he took two of his paper cups. He always had two paper cups sitting of water
Okay.
on the little, by the door, and he had crushed those and took the bread, tossed the bread, and he put the sandwich meat between the bread and ate it.
Put the sandwich meat between the bread or between the
Put
cups?
the sandwich meat between the two cups and was attempting and chewing on the cups
Okay.
and the meat.
And the paper too?
Yes, the paper cup.
And there's a note there about a trick that he did or something? What was that?
He had another cup that he, was flattened,
Yes, ma'am.
and he tossed it through the grate the slot where you have the food coming in.
Yes, ma'am.
He tossed it through there.
Okay.
Yeah.
What does it mean when in your note says, did backward somersaults with a cup balanced on his penis during the trick?
Yes, that trick. Many times he tried to do a backward flip with a penis delicately, precisely placed over his penis area, and then try and jump backwards and see if he could keep it in place. He did not succeed, but he tried several times.
Was this behavior, how long had you worked in the jail?
12 years.
Was this odd to you to see this kind of behavior?
It's odd behavior. I've seen very odd behavior.
Okay. You've seen other people that have
Much.
demonstrate odd behaviors?
Definitely, yes.
Did some of those people have mental illnesses?
Yes.
The next note, I think, is on the next day, November 13th, and it's at 10:01 a.m., I believe. Is that right?
That's when I started the chart, yes.
Okay. Is there a note there about him being moved from that one cell BC5 into another cell BC4 on the blanket, moved on the blanket?
Yes, I was there with him when they moved him.
Okay. Why did they move him? Do you recall?
The room was not fit to live in. It was full of feces, and he was too.
Okay.
So we moved him out of that room into a clean room.
And do you know whether or not whether there's video cameras in these rooms that are recording at least some of this?
It should have been recorded at all times.
It should have been recording at
Yes.
all times. Now, at this point in time, if you look at that note from 10:01 a.m. on the 13th of November 2012, was Mr. Holmes able to stand up at that point? Do you know?
He was not.
What was he like? Was he when they tried to move him from that one cell to the other? How did he respond to that?
He was in another frozen position, unable to move, stand up. He was in a very tight frozen position, so we just put him on a blanket and they,
Okay. At
moved him
some
across the hall.
okay. At some point that day, did you notice him like flailing around on the floor, like naked on the floor, kind of flailing around, or?
He was, he wasn't, I can't say he was flailing.
Okay.
He didn't respond, I went to do a welfare check on him when we got him into the new cell.
And is that one of the things that you regularly do when someone's moved into one of those cells?
We check on them, especially because if they're acting, whether it's disciplinary or his was for medical reasons, because he wasn't, acting like he was well.
Okay. And so that welfare check, do you just go in and try to communicate with them and see how they're doing?
See if they're oriented, communicate, find out what's going on, what we can do.
Okay.
And he was not cooperative.
Was he able to respond to that?
No, I asked him what was going on, and he just mouthed. I couldn't even figure out what he was mouthing. He was just mouthing.
Like mouthing words?
Mouthing looked like mouthing words.
Did any words come out?
None.
What did that seem like when he was doing that? Did it seem like he was trying to talk, or could you tell, or?
It looked like he was trying to talk, but nothing came out.
What is this? There's a note there about sclera.
Eyes. I wanted to check his eyes because he'd had a head injury,
Okay.
and he had a bump on his head, and I wanted to check his eyes and see how he was doing and see what his pupils were doing, and he resisted, so I opened them, and they were very bloodshot and very full of looked like to me tearful, wet,
Tearful.
very wet.
At some point that day, did you attempt to get a blood pressure on him, and deputies had to kind of restrain him?
He wouldn't let me do a blood pressure. He tightened up really, really tight. He was already in a tense position, but he would not cooperate with me to get a blood pressure cuff on.
Okay.
The same way with his eyes. He had his eyes squished shut. So that's why I had to open them to take a look at his pupils.
You had to open them with your fingers to open his eyes?
Yes.
And what else do you note in there? Was he having a problem with feces again in that cell as well?
Not while I was in there.
Okay. What else does it say in that note that you noticed that day?
What concerned me was the fact that he had the bump on the head. He was not responding. He was acting, and I wanted to rule out and make sure he didn't have like a concussion or hurt his neck.
Did you have a doctor come take a look at him then, that morning?
Dr. Grope.
Okay. And is that Dr. Jason Grope?
Yes.
Was he one of the doctors that worked at the jail at that point?
Yes, he was.
And did he come by around 9:30 to make an assessment of Mr. Holmes that morning?
I know he came in and took a look at it. I don't know if it was 9 o'clock. 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 9 o'clock.
Okay.
I
It's been a
don't-
long time, right?
No, I don't have my glasses on, so I'm trying to read this.
You can borrow mine if you want. And Dr. Grope, is he a psychiatrist or is he a medical doctor?
Medical doctor.
Okay. Do you recall whether at that point in time, Dr. Grope gave Mr. Holmes an IV?
No, when he was, I understood he got the IV when he was in the ambulance, when the ambulance people came.
Before the ambulance people came?
Yeah.
Okay. And so was that day that the ambulance came on the 13th? If you look at your note from the 13th of November 2012 at 11:34 a.m., does it indicate that that's when the ambulance came?
Right.
So was it before that Dr. Grope administered an IV?
I don't remember the IV, other than the ambulance saying that they put an IV in him when they came back from
Okay.
bringing him back from the hospital.
Okay. And do you remember anything else about what he looked like or acted like when he was in the ambulance and they were getting ready to take him?
Well, when the ambulance got there, he was able to get up and get on the gurney,
Okay.
which surprised me. And then I followed him to the ambulance, and they put him up in the ambulance, and I took one last look at him, and he was like totally scared.
Okay.
Eyes were moving around like, what is going on here? And he was crying.
Okay. I think your next note is from the same day, the 13th of November 2012 at 13:51, which I think is 1:51 p.m. Was that the time about when he returned back from the hospital
Right,
that same day?
that same day.
Do you know whether or not that's when he got that CAT scan, the first CAT scan?
Yes,
And was it then that they'd indicated that he did receive some IV fluid while he was in the?
that the ambulance driver, when they brought him back, said they had given him 500 cc's of IV fluid
Okay.
while on the way to the hospital.
Now, when he returned, was he all better, or was he in the same disposition as when he left?
Same
basically?
disposition,
Was he still unable to really communicate?
unable to communicate.
Was he mumbling?
No,
Okay. Did you try to weigh him or assess him somehow?
they were looking for, just to make sure about comparing his weight to see if he lost a lot of weight, because he hadn't been eating or drinking for the last 48 hours, really.
Okay. Did it appear like he was aware of what was going on?
No, he was not.
And did you, was that the last day until the 18th? Did you have some days off there?
I had
starting
days
that?
off, yes. That was it.
And was that really the last contact that you had with Mr. Holmes?
Yes.
Was that day?
That day.
Okay. May I have one moment, Your Honor?
Yes.
Thank you very much, ma'am. I have no other questions.
Thank you.
Cross-examination, Mr. Orman.
Thank you. So you've just been talking with Mr. King about, I'm sorry, good morning, ma'am, about this incident that happened in mid-November, which was about 1 week short of 4 months since the shootings in the movie theater, right?
Yes.
I want to ask you first about this ambulance. You testified, I think, that he was sort of unresponsive on the floor. You couldn't do any medical checks on him. Wasn't moving around. He had stiff limbs. And you take him to the ambulance bay, and the ambulance arrives, and he sort of pops up and walks over to it, right?
In the cell, when the ambulance, they come to the Sally Port, then they came to his cell.
Okay.
And it was time to get up on the gurney, and
Yeah.
he got up and got on the gurney.
No
Walking
problem.
swiftly, but he got up and he actually helped them get himself onto the gurney.
So he stood up, yes?
Yes,
And then seemed to understand what the gurney was there for,
yes.
and put himself in the gurney.
He assisted himself with the ambulance people to get up on the gurney.
Okay. And then a few hours later, Well, and did that seem to be different from what you had observed an hour before, around 10 o'clock?
I wasn't expecting him to get up. I thought we'd have to lift him up on the blanket.
So based on the way that he was previously behaving, you thought people would have to, that he would be totally unresponsive, wouldn't know what was going on, and actually have to be lifted up and put onto the gurney.
Yes,
But instead, he stood up on his own and put himself in the gurney or helped them do that.
yes.
Objection misconstrued the testimony. She said that he's, with the assistance of the ambulance personnel, he got on the gurney.
The objection is overruled.
So that was a yes?
That was a yes.
I want to now go back in time, because you've talked about your observations of the defendant, I think throughout the time that you saw him at the jail, and specifically we're talking more about November. I'd like to go back in time to July. And would it be fair to say that that's sort of when you first met the defendant, when you first had an opportunity to see him in the jail?
Yes,
Now, the first note I have, and tell me if this is in fact the first time you would have seen him, would have been around July 29th. Does that make sense?
yes,
And fair to say that in July, when you saw him, he was responsive to you when you spoke to him
yes.
and would answer your questions,
Briefly, 1 or 2 words.
but still answer your
He'll
questions.
answer.
If you said, "Yeah, how are you doing?" he wouldn't say, a basset hound. It was an appropriate response.
Yes,
So July 29th, 2012, and about 1:20, 1:21 in the afternoon, you saw him, and he was answering your questions with yes or no questions, right?
yes,
And he ate all of his lunch on July 29th, right?
I'm not looking at my notes, but I would, if I said yes, he's,
Okay, would it help to look at your notes for July 29th?
And for the record, the witness is looking at her notes.
okay, July 29th at 13:21?
Right.
Okay,
So, so he answered your questions with yes or no comments, right?
yes,
Ate all of his lunch, right?
yes,
Rested on his bed, and he got up to use the toilet, correct?
yes,
Appropriately, right?
appropriately.
And because of the whole jail or something was on lockdown, he couldn't get out for his time out of his cell, right?
Yes,
But on other occasions, you did see him get out of his cell for what you call the time out from the cell.
yes,
Let's go to July 30th. At 7:58 in the morning, you have a note, and he ate all of his breakfast and shaved, correct?
yes,
And was cooperative.
yes,
A little later, the next day, in fact, July 31st, at around 1:35 in the afternoon, again, you had seen him that day, correct?
yes,
And he was compliant and cooperative on July 31st, right?
yes.
It says in your notes he completed ADLs. Can you explain what that means, ADL?
Activities of daily living, that means he got up and he took a shower, walked around, shaved, ate breakfast, did what he wanted to do,
In fact, he ate both of his meals
ate
that day.
both of his meals.
And he requested and got approval to have time out of his cell at that time. Is that what that says in there?
Yes,
I think I skipped a day. Let's go to July 30th, and specifically the morning. He ate all of his breakfast and shaved and was cooperative on that date, correct?
at 7 in the morning, yes.
Yeah.
8 o'clock, yes.
Now, on July 29th, you also had to do something with the defendant that you do for everybody that goes into the jail and do a TB test, correct?
Yes,
And that's for purposes of ensuring that nobody brings an infectious disease like tuberculosis into the jail. And on that date, you gave him the TB test, and he responded compliantly with brief eye contact when you did that.
yes,
And again, he ate most of his breakfast on that date, correct?
yes.
I want to go forward to another note that you have for some dates in August. And I want to start with August 15th on that date. On that date, you noted that he had contact lenses delivered to him. Is that right?
Answer down. What time are we looking at?
You know, it's a different type of note. Would it help you if I showed it to you?
It would, but
Okay.
I know he gets his contacts delivered.
Would it help to show you this
Sure.
note? And if I may approach, Your Honor.
You may.
Can I ask you a few questions up here, Your Honor?
That's fine. If you would use a microphone, please.
So what do you?
Oh, that's my pen. I was going to point to something there. If you can look at that bottom one right there, is that saying that he got his contact lenses delivered that day?
The case was provided.
Okay. The case. What does that mean?
What holds the contacts?
And then let's go to the 21st. And I don't know if you have a separate note of that, but you write in here how he says, how does this ABX work? What's it called? What's ABX?
Antibiotic.
So you were giving him some antibiotics?
An antibiotic for his finger.
For his finger. What had happened to his finger?
I don't know what happened to it, but it became infected, the nail bed.
So you gave him some antibiotics, and he asked you, how does the antibiotics work?
Yes.
Did he ask what the antibiotic was?
I want to know what it was and how did it work.
Then let's take a look at the note here for August 26th in this area, where you say met his own ADLs. Again, that's he was doing his activities of daily life, right?
Yes,
No problems with that.
no problems.
Ate both of his meals. Is that right? You want to take a look at this.
Okay. Where am I at?
There.
Ate both of his meals.
And then let's take a look at the
Watch
next
TV.
one. Watch TV. Looks like up a little higher on this, we have a note about the Band-Aid or the cut on his finger from August 20th. And he said to you, I need another Band-Aid. The one you gave me broke open, right?
Yes,
On August 23rd, he took his meds, presumably the antibiotics, without difficulty, right?
right.
You exchanged the Band-Aid, and there was no problem doing that, right?
None.
He ate all of his breakfast, correct?
Yes,
And at that point, he was allowed to have his commissary, right?
yes.
And what's commissary?
Food that they can buy
Okay.
and bring in for personal.
I have some notes here from September that I want to ask you about. Specifically starting with September 9th. And you have a note from 2:26 p.m. on that date. Ate both meals, showered, did not shave, no concerns expressed, correct?
Yes,
So he was essentially acting normally on that day
yes,
in September.
in September.
Then we have a note from September 10th at 2:36. Do you have that?
2:36 p.m.
Yes, I'm looking at it.
And on that date, didn't have much activity, slept for most of your shift, refused breakfast, but did eat his lunch.
Yes,
On September 11th, he ate both of the meals that you were there for on your shift, and he showered and watched television on his timeout, right?
yes,
And then occasionally would sit at the side of his bed and read.
yes.
Is there anything unusual about someone sitting on the side of their bed and reading at that part of the jail?
No,
And presumably reading a book?
yes,
Because the people in there can get books and
yes, they can.
Okay. Then let's go to September 16th, at, again, close to 1:57 p.m., around 2 o'clock. You observed him up early doing exercises that day, right?
Yes,
And he ate both of the meals that you were there for on your shift,
yes,
and he took a shower and shaved.
yes,
Fairly normal activities.
normal.
On September 18th, at about 12:35 p.m., you have a note. On that date, he was up at his bedside occasionally. You renewed his contact lens solution. He ate both of his meals, correct?
Yes,
And he was resting quietly, had not had his time out of his cell yet.
right.
Then September 19th, you were there again. He completed his morning activities of daily life, right?
Yes,
With no problem.
no problem.
He had a professional visit and returned without incident, correct?
Yes,
September 24th, you have a note, and a note for your, so you can take a look at it if you want to, is from 1:22 p.m. Ate both of the meals that you were there for, correct?
yes,
Again, had a professional visit and returned without incident, right? I'm sorry, I think
Yes.
we spoke over each
Oh,
other
I'm
for a
sorry.
second there. It's my fault, my fault. Again, he completed his activities of daily life with no problem, and he was showering,
yes,
correct? And he took his time out of his cell without any problems.
yes,
On September 25th at 2:30 p.m., you have a note where you observed him exercising in his room, correct?
yes,
And nothing, again, nothing unusual about an inmate there exercising in their room, correct?
correct.
And that's pretty normal, right?
Normal.
He showered and then returned to his room during his timeout, correct?
Yes,
Again, normal stuff.
yes,
I'm going to object to the continuing reference to normal.
Sustained.
Let's go to September 30th, 2012. You have a note there it's for your reference date with 2:24 p.m. On that date, he ate the meals that you were there for, correct?
yes,
He showered and watched TV,
yes,
correct? And appeared to rest for most of that shift, right?
yes,
On October 1st, you have a note for, so you can take a look at it, from 1:21 p.m. He watched TV on his timeout. You saw him do that, right?
yes.
And that was a typical activity for him?
Not as usual.
Okay, why is that?
His choice.
Okay. He took a quick shower, and again, no incidents noted, correct?
Right, correct.
Then the next date, October 2nd, for your convenience, your note is from 3:24 p.m. You observed that he spent most of his, most of your shift, resting and sitting at his bedside, but he completed a shower and returned to his room, correct?
Yes,
I think the next one I have is October 28th at 2:49 p.m. Do you have that one in front of you?
$249.
2:49 PM, October 28th. You see that?
Yes, I do.
Okay. And on that date, you observed him doing his activities of daily life with no problem, correct?
Yes,
And you saw him exercise for 20 minutes or so, right?
yes,
And he showered, watched TV, ate both meals, right?
yes,
Then, at some point during that shift, you asked him how he was doing, and he said, "I'm good."
I'm good.
Now, he didn't make eye contact with you, but he said, "I'm good."
Yes,
A couple days later, in fact, the next day, I'm sorry, October 29th, and for your convenience, your note is from 1:46 PM. You saw him showering on his timeout, and he watched TV.
yes,
Then the next date, October 30th, and your note for your reference is 2:27 PM. You saw on that date that he showered and he exercised, right?
yes,
And he read for a short time.
yes,
And he spoke briefly with the deputy about his exercising and said it was something for him to do.
yes,
The next one I have, and take a look if this will help refresh your memory, is October 22nd at 2:26 PM. And tell me when you got there so you can take a look at it.
at 14:26?
I have, yes, 2:26. Thank you. On that date, he took his time out of his cell, he showered and watched TV and ate both meals, right?
Yes,
And October 23rd, he had some type of professional visit, and he showered and watched TV on his timeout, and you didn't record any incident, right?
right,
Looks like I skipped a couple, so I'm sorry, I have to go back in time. So we have October 14th, and you have your note, I believe, is at 1:47 PM.
yes,
On that date, he was offered juice, and he said nope.
yes.
Was that a typical way for him to respond, nope? If you remember?
I've not heard nope very often. It's just usually no.
On that date, October 14th, he showered on his timeout, ate both meals, right?
Yes,
Again, no incident recorded,
yes,
at least by you. Then October 15th, and your note is from 2:23 PM. Showered and watched TV, spent a quiet day, and appeared to rest in his bed after a brief exercise period.
yes.
Again, no incident recorded.
No incidents.
And let me go back a couple more days. October 9th, and your note is from 2:59 PM. I had some small talk with the deputy, right? The defendant did.
What time are we talking?
It's October 9th, 2012 at 2:59 PM is your note.
Yes,
And he showered and watched TV,
yes,
and again, you didn't record any incident,
Right.
correct?
yes,
October 7th, on that date, and your notes from 3:44 PM, ate both of his meals, showered, sat up a while to read, and he didn't give any concerns.
right.
And again, no incident recorded.
No incidents.
I think I just got a couple left here.
October 16th, and I think your note is from 3:10 PM. Tell me when you got there.
I have it,
Again, no incident recorded that day, correct?
right,
And when asked, he voiced no concerns, correct?
right.
And October 21st, and your note, I think, is from 2:02 PM. And this is the last one I'm going to ask you about. Why don't you tell me when you got there?
I'm there,
On that date, again, no incident recorded, right?
right,
And he took a shower on his time out and went back to bed and ate both meals, right? Is that, yeah, is that a yes?
Yes.
And on that shift, he didn't watch TV.
yes.
Okay. I don't have anything further. Thank you, Your Honor.
All right, is there any redirect?
No, Your Honor.
All right, the jury appears to have some questions for this witness. Give us a moment, please.
Yes.
Thank you. Would counsel please approach? Ma'am, the jury has submitted some questions that, based on the rules of evidence and other applicable rules of law, I have determined are appropriate. The first question is, from July 2012 to November 2012, did you ever give Mr. Holmes any medications?
Outside of the antibiotic, no.
The next question is, if yes, what were they? And you've answered that. And the follow-up question is, if no, do you know why? And I think you've answered that as well. The next question is, how did Mr. Holmes cut his finger that then became infected?
I don't think he cut his finger. It was like maybe biting his nail. It was really, really low, and it got infected.
The next question is, as a nurse in the jail, are you aware of the mental and physical status of the inmates that you're dealing with?
Yes,
Who controls or decides what medications are given to the inmates?
the doctors.
And how is that communicated to you?
If they want them on medication, we get a doctor's order to administer it.
Any follow-up questions based on those questions, Mr. King?
One, Your Honor. With regard to the doctors prescribing medicines in the jail, would that include both medical doctors like Dr. Grope as well as a psychiatrist, Dr. Mosier?
Yes,
So if any of the inmates in the jail had psychiatric problems that required medication, it would be Dr. Mosier that would prescribe that medication?
Dr. Mosier.
And that was his responsibility?
That was his responsibility.
Thank you, ma'am.
Any follow-up questions from you, Mr. Orman?
And you don't know what limitations might have been placed on Dr. Mosier by someone refusing to speak to him, do you?
No.
All right, may this witness be released from our subpoena, Mr. King?
Yes, Your Honor.
Any objection?
No, Your Honor, thank you.
All right, ma'am, thank you.
Thank you.
All right, members of the jury, it's 10:25. Let's go ahead and take our morning break at this time. Let's take our usual 20 minutes. Please make sure you comply with all my admonishments during the break. Thank you. The record should reflect that the jury has exited the courtroom. Everyone may be seated. Let's go ahead and take our morning break, and I'll see everyone back here in 20 minutes, all right? The court will be in recess. Thank you. seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury, still having some issues with the restroom in one of the jury rooms, so we're dealing with that. Are the parties ready for me to bring the jury in when the jurors are ready?
Your Honor.
Yes, Your Honor.
Okay, great. See if they're ready yet, please. Please be seated, everyone. The record should reflect that the jury's back in the courtroom. You may call your next witness, please, Ms. Brady.
Your Honor, we would call Jeremy Leadham.
Good morning. Could I have you raise your right hand for me so that I can administer an oath? You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. All right, please be seated. Please tell us your full name and spell your first, middle, and last names.
Jeremiah Leadham, Jeremiah, no middle name, last name Leadem.
Mr. Leadham, can you just pull that microphone? It moves on the table there. If you can just pull it a little bit so everyone can hear you. Thank you. Can you please tell the jury where you worked in November of 2012?
I worked for Action Care Ambulance.
And are you a paramedic?
I am.
Do you recall working on November 13th of 2012?
Vaguely, yes.
And do you recall being dispatched to the Arapahoe County Jail?
I do.
Now, is Action Care Ambulance, is that part of a hospital, or is that a private company, or what is it?
It's a private ambulance company.
Okay, and do they make calls to the Arapahoe County Jail when necessary?
Yes, at the time they were contracted with Arapahoe County Jail to handle any medical transports for their detainees.
All right. When you were dispatched to the Arapahoe County Jail on November 13th of 2012, when you went there, did you know who you were going to pick up?
Upon not initially with the dispatch, they just gave us patient age and gender, as with most dispatch information. We didn't know who we were there to see until we were greeted by infirmary staff.
And what information were you given once you got to the jail
Objection, hearsay.
for purposes of medical diagnosis or treatment?
Well, did he do, why don't counsel approach, please? All right, the objection is overruled.
Sir, can you tell the jury what you were told once you got to the jail?
I was told the name of the patient I was picking up, which was Mr. Holmes, and the circumstances which brought us there. They want to pretty much just tell us why he was being transported to hospital and give us a brief rundown of his medical history, everything pertinent we needed to know to be able to treat him correctly on the transport over.
And can you tell the jury what information you learned about why they wanted him transported to the hospital?
They stated that on camera they witnessed him voluntarily hold his arms out, fall backward, deny that he struck his head or anything like that, deny any loss of consciousness. After he fell to the ground the first time, he was able to get back up. He got up on top of his bed and then proceeded to do the same motion, arms out, fell backwards. Once again, didn't hit his head, didn't lose consciousness. After which they noticed he started exhibiting combative behavior, became erratic with any of their assessments, and they also noticed a bruise across his forehead. And so out of concern for any possible head injury, they wanted him transported to Denver Health where they could run more comprehensive CT scans to determine if there was any damage done. And so they needed our ambulance to transport him there.
Did they also tell you he was striking his head against the wall?
I believe so, yes.
When you got into the hospital, can you tell the jury how Mr. Holmes got, transported? I'm sorry, I'll start over. When you went into the jail to get Mr. Holmes, can you tell the jury how Mr. Holmes was moved from the jail cell to the ambulance?
So we essentially just brought our stretcher and all our medical equipment to the infirmary. We went to his specific cell. They escorted him out of his cell. He sat down on our stretcher. We buckled him up, rolled him the rest of the way through the jail to our ambulance, and then went on with our transport from there.
And when he was getting up onto the stretcher, were the guards helping him do that?
I believe so, yes.
Did you ride in the back of the ambulance with Mr. Holmes?
I did.
Describe what you observed about Mr. Holmes in the ride to the hospital.
Essentially, I did my best to do my normal assessment as I would do on any traumatic injury patient related to the head. Tried talking to him, tried asking him questions about his condition. He didn't seem real reliable in disclosing what was wrong. He wasn't able to hold a conversation like you and I are right now. I proceeded to ask him to do a couple things so I could rule out possible disease processes that were going on. I had him try to follow commands. I had him repeat phrases, asked him to smile, determine if he had any facial droop. He could do that. Asked him to repeat a phrase to determine if he had any slurred speech. He repeated the phrase, and he would continue to repeat that phrase over and over throughout the transport. But besides that, he wasn't real conversive, pretty much maintained a locked gaze to the ceiling of the ambulance, and if there was any interaction, it seemed to agitate him. So.
Okay. Did you try and find out whether he was oriented at all? Is that something that you do?
Yes.
Can you explain that to the jury, please?
So essentially, if someone has a head injury, we just want to determine how competent and how well functioning their brain is at the time. We just ask some very basic questions like, do you know your name? Do you know where you are? Do you know what month it is? If I had 6 quarters, how much money does that make? All that kind of gives us just a very rough understanding of how their brain is doing. And so anytime you hit your head, we want to kind of evaluate that. So I did ask him those questions. I think at best he was able to tell me his name, but that was the extent of it.
And you said something about having him repeat a phrase. Do you recall what the phrase was?
The phrase is, you can't teach an old dog new tricks. It's pretty much a phrase we just use to see if they can say it without slurring their speech. If they're slurring their speech, we are always concerned about possible brain bleed or stroke. So I had him repeat that phrase. He did with no slurred speech and continued to repeat it on the way in.
So he continued repeating the phrase over and over?
Yes.
I think you mentioned episodes of incoherent speech.
To my rough recollection of that, it was just a jumble words that really weren't appropriate for the conversation, didn't make much sense. I can't remember exactly what he said, or otherwise I may have quoted it, but I don't remember.
Okay. Did you perform any sort of medical treatment during the transport from the jail to the hospital?
Yes, we pretty much just took several sets of vitals on him. That would include everything from blood pressure, pulse checks, pulse oximetry, cardiac monitoring. We initiated an IV for him, gave him fluids because the infirmary staff state that he wasn't eating or drinking for an extended amount of time. So we gave him fluids to take care of any possible dehydration issues. And we drew blood through the IV sites as per our protocol, and no other assessments were rendered. I'm sorry, blood sugar was taken as well.
All right. Any other treatments that you did on the way to the hospital?
No, every treatment we did for him would be in the report I wrote.
All right. Did you see any injuries to his head?
I saw what I believe was an old appearing contusion or bruise across his forehead.
How big was it?
I described it as about the size of a baseball.
Now, which hospital did you take Mr. Holmes to?
Denver Health.
Were you aware what procedure was going to be performed at the hospital?
I believe the infirmary staff told me that he was going in for a CAT scan to be done.
Did you assist in transporting Mr. Holmes from the ambulance to the area where the CAT scan was done?
Yes, we went into Denver Health's Sally Port. There we were escorted. He once again was on our bed. We wheeled him into the CAT scan room and helped transfer him over to their bed. They performed the CAT scan. We put him back on our stretcher and waited for the doctor to go over the results.
How did you transport him from your stretcher to the CAT scan bed?
Can I refer to my notes?
If that would help refresh
Yes,
your memory.
please.
I don't know if I can approach.
You may.
Mr. Leadham, does that help refresh your recollection about that?
Does.
Can you tell the jury, please?
We took the sheet he was lying on. 4 people grabbed the sheets, lifted it up off our stretcher, and glided him over to the CAT scan bed.
And after the CAT scan was over, how did he get back to the stretcher?
Same fashion.
Do you recall how long the trip was? Like what time you picked him up and what time you dropped him back off at the jail?
Roughly about maybe hour, 20 minutes. All those times would be included in the report.
Would it help to see a copy of your report?
It would.
Okay. Sorry, Your Honor, if I can approach the witness.
Yes.
To go from the Arapahoe County Jail to Denver Health, we arrived at 10:53, and we arrived at Denver Health at 11:58, so an hour and 5 minutes.
And then do you recall what time you got back to the jail?
I believe that's in the report I wrote for the return trip.
All right. Is it, do you have that up there or not?
I do not.
Let's see if I- Thank you. I don't know if I can approach.
Yes.
Is it in that report?
No, it would be on the first page of this report. Looks like we departed the jail at 12:51, we departed Denver Health at 12:51, we arrived at the jail at 13:20, so roughly an hour and 30 minutes.
So 1:20 in the afternoon, you got back to the jail?
I'm sorry, no, not an hour and 30 minutes, 30 minutes.
Just take this picture. would also like to approach Mr. Leadham with what's been marked as D-TR-80.
Okay?
Mr. Leadham, does that appear to be a calendar of November 12th, 2012?
Yes.
Would you mind just circling the date it was that you transported Mr. Holmes to the hospital? And what date did you circle?
November 13th.
And if you wouldn't mind, would you write your name at the top and just put Action Care Ambulance? Now, regarding that phrase, "you can't teach an old dog new tricks," you asked Mr. Holmes to state that phrase. Just to be clear for the jury, you didn't ask him to keep repeating that over and over, right?
No.
He just kept repeating it
Yes.
over and over? Okay. Your Honor, I would move to admit D-TR-80.
No objection.
All right, without objection, it is admitted.
Thank you. I have no further questions.
Ms. Teach McGuire, do you have cross-examination?
Yes, sir.
Good morning, Mr. Leadham.
Morning.
Mr. Leadham, fair to say that you never spent any time with the defendant prior to the transport on November 13th of 2012?
No.
And no time after the transport with the defendant after November 13th of 2012?
No.
So you really had no idea what sort of affect or personality to expect from the defendant when you transported him?
No, I did not.
All right. And the defendant was able to understand some of the commands you gave him. For instance, when you asked the defendant to smile, he was able to do that.
Yes.
And if the sheriff deputies told you that the defendant was actually able to assist himself on getting on the gurney, would that be a fair statement perhaps as well?
I can't remember if that was the case on that day, no.
So you don't really know if he voluntarily did that himself or if he was assisted?
I don't know.
And the defendant only started repeating that phrase once he was asked by you to initially state that phrase?
Yes.
And he had no slurred speech whatsoever?
No.
And you took several tests of the defendant approximately every 10 minutes while you were in the ambulance with the defendant. Isn't that fair to say?
Yes, it's standard of care to check a patient's vitals every 10 minutes.
And all of those vitals came back normal with the exception of the tachycardia. Is that correct?
Yes, he was exhibiting a fast heart rate when we initially got to him. That heart rate dropped to within normal limits sometime during the transfer.
But all the other medical things that you were looking for came back normal at that point in time?
Yes.
And you are not aware of if the defendant is just perhaps not a very talkative person?
I wouldn't know that about him.
Now, would it be fair to say that the bruise that you noted on the defendant was not raised in any way? It was just a slight bruise?
From what I described in my documentation, I described it as contusion. Contusion's just a bruise. If it had any elevation, I would describe it more as a hematoma in my documentation.
You were told by hospital personnel that, in fact, the CT scan came back negative.
I wasn't told the results of the CT scan. I was just informed that we could transport him back.
Now, do you recall writing a report about that?
Yes.
If your report stated that you were told that it was negative, would that perhaps refresh your recollection?
You know what? I would have to definitely look through that real quick.
May I approach the witness, Your Honor?
May. Although I don't think this is a refresh the recollection, I think this is impeachment. He didn't say he didn't remember.
According to the report I wrote at the time, it does say that the CT scan was negative, and the only way I would find out is someone involved in his care would have told me. So.
Would you have described the way the defendant was presenting to you as presenting overly exaggerated?
Objection, speculation, lack of foundation?
I can lay more foundation, Your Honor.
Okay, why don't you lay more foundation? I'll sustain as to lack of foundation for now.
Thanks, Your Honor. You had an opportunity to observe the patient while he was in your ambulance
For roughly 3 hours, yeah.
for roughly 3 hours. You had an opportunity to observe the way that he was presenting to you at the time.
Yes,
You've had an opportunity to observe many patients over your career as a paramedic. Is that fair to say?
yes,
And from time to time, are you able to determine in your observation as a paramedic whether people appear to exaggerate their symptoms?
yes, it does happen at times.
Were you able to tell in this circumstance if the defendant appeared to be exaggerating his symptoms as you transported him to the hospital?
Objection, can we approach?
Yes. All right, the objection is sustained, but Ms. Stitch McGuire, you may proceed as we discussed at the bench.
Thank you, Your Honor. Would it be fair to say that you observed the defendant's actions to be deliberate in the ambulance ride?
Objection, speculation.
Sustained.
May I have a moment, Your Honor?
You may.
I have no further questions. Thank you, Your Honor.
All right, thank you. Is there any redirect?
Just very briefly, Mr. Leadham, there was a question about whether you remembered whether anyone assisted Mr. Holmes from the cell to the stretcher. Would you mind checking your notes and see if you noted anything like that in your notes, please?
Okay. What I have documented is that he ambulated with police support from cell to pram, roughly 3 feet, so he did have help from the deputies.
Thank you. No further questions.
Ms. Stitch McGuire, do you have any recross?
Just one question, Your Honor. So the defendant was ambulatory, though, meaning he could walk on his own.
That's what I documented, yes.
Right, thank you very much.
All right. The jury may have a question for you, sir. Give us a moment, please. Thank you. Would counsel please approach? All right, sir, the jury has submitted a question that, based on the rules of evidence and other applicable rules of law, I have decided is appropriate. The question is, did Mr. Holmes get on the stretcher while in his cell or outside of his cell?
The stretcher was outside his cell.
Are there any follow-up questions, Ms. Brady?
No, sir.
Any follow-up questions from you, Ms. Titch McGuire?
No, thank you, Your Honor.
All right, may this witness be released from his subpoena?
Yes, sir.
Is there any objection?
No, Your Honor.
All right, sir, thank you. Call your next witness, please.
Your Honor, we would call Dr. Elizabeth Loudermilk.
Come around this way, please. Can I have you raise your right hand so that I can administer an oath? You solemnly swear or affirm in the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated.
Thank you.
And can you hand me those pieces of paper?
Yes.
Thank you.
You're welcome.
All right, Ms. Brady, do you want to retrieve these reports?
Yes, please, thank you.
And Melissa, do you want to put that up? Good morning.
Good morning.
Please tell us your full name and spell your first, middle, and last names.
Sure. Elizabeth, Elizabeth, Lyons, Lyons, Duncan, Duncan, Loudermilk. Lowdermilk.
Thank you. All right, you may proceed, Ms. Brady.
Thank you. Good morning.
Good morning.
Can you please tell the jury how you're employed?
I work at Denver Health
Uh,
as a psychiatrist.
At the hospital?
Mhm.
How long have you worked there?
4 years.
And you said that you are a psychiatrist. What do you do at the hospital? Just sort of explain what your usual days look like.
I am the outpatient medical director for the Department of Psychiatry. My clinical work is in integrated care, and a usual part of my work is rotating through being on call when I might be on the inpatient or the hospital side.
All right. Do you have a medical degree?
Yes.
Can you tell the jury just a little bit of your background as far as education towards becoming a psychiatrist?
Yes, I have a Bachelor's of Science that I got in 1994 from Penn State. Unusual for going to medical school, I also have a master's degree in counseling psych. I then went to medical school at the University of Colorado and then completed a residency in psychiatry.
And can you briefly describe for the jury what sort of work you've done in the area of psychiatry?
Psychiatry specifically, okay. I have worked at Denver Health for the majority of my career. During my residency, I did what was called a career year. So I spent a year as an attending psychiatrist at a mental health center. In residency, we spend approximately the first 2 years on the inpatient or consult service. We then transition to more of our outpatient training. I've also was the chief on the inpatient psychiatry for my 4th year of residency, and then followed up with my work at Denver Health.
Okay. Your Honor, if I can approach the witness with D-TR-81, please.
Yes.
Thank you.
Dr. Loudermilk, do you recognize that document?
Yes.
And what is it?
My CV.
Your Honor, I would move to admit D-TR-81, and I would ask that Dr. Loudermilk be qualified as an expert in the field of psychiatry.
Any objection to D-TR-81 being admitted?
No, Your Honor.
All right, without objection, it is admitted. Any objection to the request to qualify Dr. Loudermilk as an expert witness in the field of psychology?
Psychiatry.
Psychiatry, excuse me.
No, Your Honor.
All right, without objection and pursuant to Rule 702 of the Colorado Rules of Evidence and the decision in People versus Shrek, which is cited at 22 Pacific 3rd, 68, Colorado 2001, the court accepts Dr. Loudermilk as an expert witness in the field of psychiatry. That means, members of the jury, that Dr. Loudermilk may now render expert opinions in that field. I remind you that you're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight that you give the testimony is entirely your decision. Ms. Brady, you may proceed.
Thank you. Doctor, have you seen a lot of patients suffering from mental illness?
Yes,
And specifically, have you seen patients who suffer from psychosis?
yes.
Is there any way to estimate how many patients you've seen with psychosis?
It would be in the hundreds.
Did you have an opportunity to meet James Holmes seated here at the defense table?
I did,
Can you explain to the jury the circumstances under which you met Mr. Holmes?
certainly. I was on call. This would have been Sunday, November 18th, 2012. When we are on call, we see people that are admitted to the inpatient unit as well as people that are on, we're asked to consult on. Mr. Holmes had been admitted to our correctional care medical facility, and the psychiatry department was consulting on him.
How was it that you were called to meet Mr. Holmes?
Me personally or the service?
Let's do both. Start with the service, and then you can explain how you specifically were involved.
Okay. My recollection is that he was brought into the emergency room on Thursday, I believe it was the 15th. He was medically evaluated, then he was transferred for ongoing care into the CCMF unit. At that point, the primary team was our hospitalist, so our medicine service, and they, that night, called psychiatry to consult. Psychiatry then saw him Thursday night, Friday. Our usual routine is to see somebody with acute symptoms daily. And I, again, was the person on call on Sunday, so I was the one to see him that day.
And when you say acute symptoms, what does that mean?
Sorry, let me take a sip of water.
Sure.
When there are active symptoms, in this case, the question was psychotic symptoms, that medications may need to be adjusted daily. There may need to be additional monitoring every day. We will see that person every day.
And we've heard about the team approach at Denver Health. Were you part of the team that sort of rotated through that area?
So the on-call, we are all part of that team. So I was not part of the regular team Monday through Friday, but again, on-call, anybody on will become part of that team.
All right.
So I, for instance, received information from the consult team on Friday and then the person who saw him on Saturday to help with continuity of care.
And when you saw Mr. Holmes on Sunday, November 18th, did you take any notes for the record?
I wrote a note, yes.
Your Honor, if I can approach the witness with D-TR-82.
Yes.
Thank you.
Do you recognize D-TR-82?
I do.
What is it?
The progress note I wrote on Sunday, the 18th.
And is all of the handwriting on those pages your handwriting?
Yes.
And did you take those notes on November 18th when you met with Mr. Holmes?
Yes.
Is that part of your regular work as a doctor at mental health?
Yes.
Denver Health?
Yes.
Your Honor, I would move to admit Defense Exhibit 82, please.
Is there any objection to D-TR-82? No, Your Honor. Without objection, it is admitted.
Can you please briefly tell the jury what you observed about Mr. Holmes when you first met him.
When I came into the room, he had recently been up to eat and shower, and he was back in restraints, but I believe he was only in 2 of them. He was,
And can I stop you? What time of day are we talking?
it would have been, I started the note at 10:40, did some chart review, so somewhere between 11 and 11:30, I would have been in the room in the morning.
Okay, go ahead.
He was awake, responding to questions. Would you like me to go through a full?
Only if you need that to help refresh your recollection, please feel free to do that.
Okay. He was answering questions. At that point, he was making sense when he answered questions. He was somewhat oriented, so he knew at that point the month and the year. He could not tell me the day or the date. His speech, he was speaking at a normal rate, at a normal volume. He did not appear pressured, which is when somebody speaks very quickly. He had good eye contact. He appeared calm. He was not agitated at that time. He was cooperative. He answered questions. He didn't initiate much conversation. He answered the question asked. He appeared at that time organized. His thoughts, his answers made sense. He did report auditory hallucinations at that time. He reported several voices. One that he described as sounding like it was coming from behind the wall. And, sorry, just checking. And he had noted or reported that it was hard for him to tell what a real voice was. So what was the voice of somebody talking to him and what was a hallucination? When asked, he told me that the voices did tell him to do things like walk around.
Can I stop you for just a second? So how long had he been in the hospital by this point? Do you recall?
We were going, so Thursday night to Sunday morning, we were going on 3 days.
And what was your understanding at that point as to why Mr. Holmes was at the hospital?
He had what appeared to be 2 main conditions. He appeared to have a psychotic disorder and a delirium that at the day I saw him seemed to be resolving. Based on my review of the chart at that point, it appeared most consistent with somebody who had become psychotic, stopped eating, and become delirious based on that.
And the delirium, is that taken care of by the medical doctors, being, the non-psychiatric doctors?
A little bit of both. So
Okay.
the medical team looks for causes for delirium. Delirium is an acute confusional state that can have multiple causes. So the medical team at that point had already ruled out infection, brain tumor, big things that we know can cause this. Psychiatry often gives recommendations for both the medications to help a delirious state as well as treat a psychotic disorder.
And how did you go about trying to distinguish whether what you were seeing was a delirium or a psychosis or both or neither?
Right. So that's in part based on history and in part based on what's in front of what I saw at that moment. A delirium waxes and wanes.
What does that mean?
There will be times when somebody is very, very confused. They have trouble paying attention, they're disoriented, and then they will have times that they are able to attend to conversation and are more oriented.
How quickly can that cycle between the waxing and the waning?
Minutes to hours.
So 1 minute they may seem okay and the next minute they're completely confused?
Yes.
Okay, go ahead.
So what you look for when you're making the distinction is you look for the times that they don't appear confused and you see how they are. So actually being able to see a time that he was more clear added support to the idea that there was a psychotic disorder there because he was still reporting symptoms.
All right. So by the time you saw him on Sunday, had he been given medication?
Yes.
What was your understanding of what medication he had been given and why?
He started out receiving Haldol, which is used for both delirium and psychosis, as well as lorazepam, which is more used for agitation. He had side effects to those medications, and so the next day on Friday they were changed, and he was on Risperdal, which is an antipsychotic. It's a situation where an antipsychotic can actually treat both delirium and psychosis. So both were being treated.
All right. And so in your opinion, by the time you saw him, was he still suffering from any delirium?
I went back later that day to ask a question of him, and at that point he appeared more confused. So at the earlier moment, he was in a clear period, but there was still some delirium going on.
So in the morning on Sunday is when you felt like he was pretty clear?
Correct.
Was it the night or the evening of
It's
Sunday?
the afternoon, somewhere between 3 and 4, I believe.
All right, and it described for the jury how he was different in the afternoon on Sunday.
Well, he was back in 4-point restraints. That's a minor point.
What does that mean?
All 4 limbs were restrained to the bed.
Okay.
He didn't recognize me. I'm not sure. He actually mentioned not being sure he had his contacts in, so I don't know how clearly he could see me. But he had a delayed response to the questions I asked. He seemed a little more confused. I prompted him with a reminder, we had talked about Risperdal this morning, and he was able to bring back some of the conversation, but he clearly didn't remember all of it. Then there was a delay in his answering that had not been as present in the morning.
Could it be that the delirium was back?
Yes.
What would have caused the delirium to come back?
Number of things. Its natural course, again, is that it will wax and wane, so more symptoms and less symptoms while you're treating it until it's fully gone. It did occur to me that the restraints might be making him more confused as well.
So as of Sunday evening, were you able to form an opinion as to whether you were seeing delirium, psychosis, or both?
I thought I was seeing both.
Okay. What makes you think you were seeing psychosis?
When he was clear Sunday morning, he was continuing to describe psychotic symptoms, and the course of the illness to date seemed consistent with that.
And you mentioned one symptom was the auditory hallucinations. Why is that significant?
It is one of the primary symptoms associated with a psychotic disorder.
Was he able to tell you how long he had been hearing these voices?
He was not. He was able to indicate to me that they had begun while he was in jail before he was transferred to the hospital.
And did you have any information about whether he stopped eating or drinking at the jail? And if so, why?
There were notes from, I believe, the emergency room in the early notes in the chart that he had stopped eating and drinking in the jail. The why, there were multiple notations of. At one point, there was a note that said the voices had told him to stop eating. His behavior at other points was described as very disorganized, and sometimes when people are very disorganized, I've seen them not be able to make a cup of coffee. When I asked him, he reported that he had, let me just double check my note here.
If that'll help
Yeah.
you remember.
When I saw him, he reported that he hadn't been eating because he had not been hungry or thirsty.
Okay. Was he able to tell you why he was in the hospital, why he thought he was in the hospital?
He said that he had, wait a minute. Sorry, found it. He said he had fallen and hit his head, and said that he had been feeling woozy for approximately a day before falling.
And was that slightly different than what you heard from the jail?
Yes.
What was the difference between what he said and what the jail said?
The jail had reported both hitting his head repeatedly on the wall, and I believe falling off, standing at the bottom of the bed and falling off and hitting his head.
When you saw him on Sunday evening, did he appear paranoid to you at all?
There was, the best I can say is what we call a flavor of that, and that's something, it's just kind of how it looks as opposed to something I could exactly say.
Okay.
But there was a flavor.
And is that something that would cause you to consider psychosis also?
Yes.
Did you change his medication at all?
I did.
And can you explain for the jury why that was?
Yes. So again, in my opinion, I was treating two different things at the same time. I was treating psychosis and I was treating delirium. As I mentioned, an antipsychotic medicine will treat both, but the dosing is different. When you're treating delirium, you use very low doses, and you're really working carefully not to add sedating meds because that can make it worse. When you're treating psychosis, you use higher doses. So my usual practice with Risperdal is 1 to 2 days of 1 milligram twice a day, and then if the symptoms remain present, and they typically are, I will increase it to 2 milligrams twice a day. Because I was balancing the need to treat psychosis with the delirium, I went up by half my usual step. So I increased it to 1 milligram in the morning and 2 milligrams at night.
And that was, your hope was to get to the psychosis with that dosage?
Without worsening the delirium,
Okay.
yes. I also continued lorazepam, and when I think that we only have delirium present, I don't, because that is a sedating medicine that can make people worse. So, but on the flip, it is a medicine that is very good for the agitation you can see with psychosis. So I made a decision to continue that as needed medicine.
Were you given information as to whether Mr. Holmes had received a CAT scan or a CT scan on his head?
Yes.
And why was there a CT scan done?
Two reasons. One, because he had hit his head repeatedly, and two, I believe that the medical team was also looking for causes of the presentation.
And what's your understanding of what the results of the CT scan were?
Unremarkable. It was a normal study.
So tell the jury what they might have been looking for on a CT scan.
A brain tumor would be the most glaring, a bleed, things that take up space in the brain that then can lead to an altered mental status.
Can a CT scan answer the question as to whether someone's mentally ill?
No.
Or psychotic?
No.
Or delirious?
No.
Okay. Did you see any evidence of delusions with Mr. Holmes?
I did not personally.
Do you feel like you had enough conversation with him to where you could be certain that he had no delusions?
No.
What would it take to find out whether someone actually had evidence of delusions?
It would take a more careful questioning, asking about common themes, paranoia, worry about others. I sometimes ask, do you feel safe? Do you feel like people are after you? Do you have any ideas that other people think are funny? You try a couple different ways to get at them, and then sometimes you can, just in letting people talk, they will emerge.
All right. And you did not do that sort of thing with Mr. Holmes?
No.
Can I have a moment, Your Honor?
Yes.
Thank you. Your Honor, I would ask to be able to publish D-TR-82, please. I do have copies.
Okay. Give them to my staff, please.
Thank you.
Do you want to do that now, or do you want to do it after the cross-examination?
I can leave that up to the prosecutor if they want the jury to see the notes first, or I can wait till the end.
Do you have, okay, do you have a preference?
Probably, I'd prefer to cross first.
Okay. Let's do that then. We'll distribute them after all the questions. Ms. Pearson.
Dr. Loudermilk,
Yes.
now you didn't see the defendant until he'd been in the hospital for 3 days, correct?
Correct.
And the amount of time you spent with him in the morning was 15 or 20 minutes?
Yes.
And then another 5 or so minutes in the afternoon?
Correct.
And you'd never seen him before that date,
Correct.
and you never saw him after that date?
Correct.
So you don't have any knowledge of what his affect or personality or speech patterns are on the regular basis?
Outside of other people's descriptions, no.
And the descriptions you got only related to the last couple of days in the hospital and in the jail, correct?
Correct.
Now, as a psychiatrist, normally when you're trying to determine whether somebody is psychotic or what is causing their behavior, you would do a history, right?
Mm-hmm.
And you need to answer yes for the
I'm sorry,
courtroom.
yes.
And in this case, you didn't take a history and find out about his past behavior or learn how he'd been since July 20th in the jail, did you?
There was some history taken, not all of it.
And the history that was taken really only related to the last few days in November, almost 5 months after the date of offense, correct?
To the best of my understanding, yes.
So in terms of how you would normally be trying to assess whether someone is psychotic or whether it is a delirium brought on by not eating, you didn't have that information available to you.
What I didn't have was the amount of time the symptoms were present, which can shape which specific diagnosis it is. You don't need a whole lot of history to determine if someone is psychotic right now. When you try to get more specific with a diagnosis, you need that history.
And you don't know if his symptoms simply came on as a result of having been in jail for almost 5 months, correct?
I don't know when his symptoms came on.
Would you agree that a person being relatively isolated in a jail for 5 months could in fact cause someone to become psychotic?
The way I think about it is there's two things, there's a psychotic disorder and psychotic symptoms. Many things can cause psychotic symptoms. A psychotic disorder will have a particular time course.
And I don't think that was a very good question for me to ask. So in terms of someone developing what you have described as psychotic symptoms, those could occur by virtue of having been in jail for almost 5 months, knowing you're facing possibly the death penalty, and being very isolated, correct?
Objection, compound question.
Overruled?
Correct? That environment could
I
cause
guess
that.
the way that I've been trained to think about it is when psychotic symptoms are present, there is some form of diagnosis. Any stress can result in symptoms.
Okay, any stress, and you would agree it would be very stressful to be in a jail, to be isolated, and to potentially be facing the death penalty.
Yes.
So those are things that could bring on psychotic symptoms.
Correct.
And in fact, that being in that environment could cause a person to decide not to eat or drink anymore, couldn't they?
Yes.
And if you don't eat or drink, the electrolyte and metabolic imbalance can cause you to have delirium.
Correct.
And you could have a delirium and therefore develop psychotic symptoms from that too. Wouldn't that be correct?
Yes.
And without being able to do a complete history and to learn more about how the defendant was and when this came on, you really weren't in a position to determine sort of the chicken and the egg, which came first here.
Correct. Well, actually, let me qualify that. It did seem clear that both were present. I don't know the order of which things developed.
Now, you said that the defendant was reporting auditory hallucinations to you,
Yes,
but you didn't see him responding in any way to any auditory hallucinations, did you?
correct.
And the auditory hallucinations, the only evidence you have that they exist then is simply that he was reporting them, but you didn't see him looking to answer based on what any auditory hallucination appeared to be telling him.
Correct.
He never reported to you any kind of visual hallucinations at any time, did he?
I believe not, no.
And he didn't say that there were any shadows telling him to do anything, nothing like that?
He said the voices told him to do things like walk around.
And when you were speaking with him, though, you said he wasn't agitated or restless, so he wasn't walking around, was he?
He was restrained.
Okay. Did he in fact deny having any visual hallucinations?
Let me check my note. Looking at how I have this written, it's not clear to me that I asked specifically.
Okay. But there was never any kind of report about any visual hallucinations?
Not that I recall.
And you didn't see any evidence
To me or in the record?
to you or in the record
There was something in the record, in one of the early notes about food or something looking red.
but to you, he didn't report any visual hallucinations?
Correct.
And you certainly didn't see anything that he was doing that would indicate he was having or responding to visual hallucinations?
Correct.
In fact, at the point that you saw him where he had received electrolytes and been hydrated, the delirium seemed to be resolving.
Correct.
He had been sedated over the last few days, correct?
Yes.
And sedating drugs can cause a person to seem somewhat confused
Yes.
and to be slow in their responses.
Mm-hmm. Yes.
Now, it seems that not just you, but there were a variety of different doctors that saw him, and all of them spent a relatively limited amount of time with the defendant. So based on the fact that delirium symptoms wax and wane in a period of minutes, as you said, or to hours, it's also possible that he's waxing and waning at the time that different doctors are seeing him, correct?
Yes.
And because they spend such a limited amount of time with him, they don't see the opposite side of it, whether it's the waning of it.
It's possible.
And it could also then be interpreted as being related to psychosis when it's simply the waxing of the delirium. Wouldn't that be correct?
If all you saw was somebody when they were very delirious, I guess I'm trying to understand that. I'm sorry, I'm not sure I understood the question.
And it may not be a very good question since I'm not a psychiatrist. But if the symptoms of delirium wax and wane, so sometimes they're more present than at other times.
Right.
And you spend a very limited amount of time with the defendant, and you don't see both of those things. You only see one of them.
Right.
And therefore, trying to determine whether or not it's delirium or whether it's actually, and calling it psychosis, it in fact could just be the delirium because that's the only amount of time you saw a defendant, right?
It could be.
One moment.
Okay.
Thank you. I don't have any more questions.
Do you have any redirect, Ms. Brady?
Yes, sir. You were asked a series of questions about whether the stress of being in jail or the stress of being charged with murder, the stress of facing the death penalty could have made Mr. Holmes psychotic, correct?
Yes.
And I just want to make sure the jury understands what you were saying. Can you explain that again about what role can stress play with psychotic symptoms?
Stress can trigger an episode of psychosis, but in the sort of diagnostic language and the way we think of illnesses, there is an illness present.
So there's sort of a dormant, is it fair to say a dormant illness, and then the stress causes it to bloom?
Exacerbate, yes.
Exacerbates it,
Yes.
that's a better word. when considering whether what you saw was a psychosis or not, if you had been given a history that just 5 months prior to this, 2 other psychiatrists were concerned that he was on the verge of a psychotic break, would that have been relevant to your assessment?
Objection, Your Honor. This would be beyond the scope of what she was requested to do.
Sustained.
Your Honor, can we approach?
Yes. All right, the objection is overruled. Ms. Brady, you may proceed.
So I think my question, Doctor, was if you had, as part of the history, that just 5 months prior to that, 2 psychiatrists had suspected Mr. Holmes was on the verge of a psychotic break, would that have been relevant to your assessment?
Yes, it would have suggested that there were either early symptoms or what we call prodromal symptoms that you commonly see early on, before you really know what they are, or before they declare themselves, and it would have led stronger support to a psychotic diagnosis.
If you had as part of your history that Mr. Holmes came from a biological lineage of other folks who had psychosis, would that be something that would be relevant to your assessment?
It would have been considered a risk factor for the development of psychosis.
Why is that?
We know that it's at least in part a hereditary illness.
If you were aware of rambling philosophical writings done by Mr. Holmes prior to the stress of the jail or the stress of the charges, is that something that would have been relevant to your assessment?
Yes, potentially writings that were rambling, and I'm sorry, the second term you used?
Philosophical.
Okay. The rambling is what caught my ear more. I would have looked at the quality of the thought and the organization of thought, and it could have suggested also early signs of a psychotic disorder.
Okay, so are these examples of other history that you would have taken into account when deciding whether what you saw was psychosis based on an illness versus just psychotic symptoms in the present moment?
Yes.
Does the presence of delirium obviate the psychosis? Does one cancel out the other?
No.
Can they coexist?
They do, and in fact, the presence of a mental illness sometimes makes delirium more likely.
And I think you explained that earlier about the causes of not to eat or drink sometimes.
Yes.
Do you believe that Mr. Holmes was psychotic when you saw him?
Yes.
Thank you.
Recross.
Dr. Loudermilk, along those lines, if as part of the information that you had at the time that you were looking at him would be knowledge that 2 court-appointed doctors evaluated the defendant and found him sane, would that be pertinent to your evaluation as well?
Objection, relevance.
Overruled?
Your Honor, can we approach?
Yes. All right, the objection is sustained, so I changed my mind, but Ms. Pearson, you may proceed as we talked about at the bench.
Dr. Loudermilk, if you had also had an opportunity to read writings that talked about planning and deliberation and considering and rejecting different targets for your crime, would that be something that you would have considered in deciding whether this is a psychosis brought on by mental illness or by now sitting in jail for a long time?
You can be psychotic and still plan. That's more of a legal question than a clinical one.
And if you found the defendant was able to participate in his life and had a relationship with a girlfriend and could go to the gym and go out in public and do all of those things during the time of the crime, would those be things that you would want to consider when you're trying to determine whether or not this person was psychotic or prodromal, 5 months earlier?
So forgive me, I'm not trying to determine if he was psychotic 5 months earlier, but if I knew that there were symptoms present, if I'd been given evidence of symptoms present that were emerging over time, I would take that into account at the time I saw him. Prodromal symptoms can be rather subtle. Certain illnesses often occur when people are of college age. They are functioning. They may or may not be in relationships. So there can be lower level symptoms that are present despite people doing multiple things in life.
Fair to say you weren't given any history about what was occurring at the time of the offense almost 5 months earlier, correct? Or in the months prior to that?
Correct.
Or even in the months after that, from July, August, September, October, even the first part of November, you got no information about the defendant during any of that time, correct?
Correct.
So your opinions were based strictly on what you saw on one day for 20 minutes after the defendant had been in the hospital for 3 days in the middle of November, correct?
Partially. My opinions were based in part on my direct contact with him and a review of the information we had, which I believe started on Thursday.
And you would agree that you don't have any information about when any of his behaviors started to change and how far back that goes?
Correct.
Thank you.
All right, there did not appear to be any questions from the jury. We're going to go ahead, there may be a question from the jury, okay.
Also, Your Honor, I was hoping to publish the exhibit too.
Okay, we're going to publish the exhibit. Do you want to hold off on the jury questions until the exhibit is published?
Perhaps Ms. Pearson and I and you can talk about the ones that are submitted, and then we can let them read and see if there are any additional.
Okay,
Sound
that's
good?
fine. Why don't you hand those to my staff, please? Doctor, you'll have to stay here for just a moment, okay? Thank you. Would counsel please approach? All right, the record should reflect that we just finished publishing Exhibit D-TR-82. All right, Doctor, the jury has submitted a couple of questions that, based on the rules of evidence and other applicable rules of law, I find are appropriate. The first question is, did you have to get permission from anyone to give Mr. Holmes medication? And if so, who did you have to get permission from?
No, we did not need to get permission from anybody. He was accepting the medications. There are circumstances when medications can be given against somebody's will if they are not accepting them.
All right, the next question is, can a person who's being properly treated and medicated have a psychotic break and delusions?
Yes,
The next question is, Ms. Brady asked about a family history of mental illness, and 2 doctors indicated mental illness. Would that change your opinion if the patient had then had the added stressor of committing this crime? Could that have caused a psychotic break? So it appears to be a 2-part question, and I'm happy to read it again.
if you don't mind, thank you.
All right, maybe I'll ask it one at a time. The first part is, Ms. Brady asked about a family history of mental illness. 2 doctors indicated mental illness. Would that change your opinion?
No,
The next part is, if the patient had then had the added stressor of committing this crime, could that have caused a psychotic break?
it could be, yes, a significant stressor can result in a psychotic break, so the, say, first full appearance of an illness.
All right, any follow-up questions from you, Ms. Brady?
Briefly, so following up on those 2 questions that were asked there, the first one was whether knowing a family history of mental illness and prior to psychiatrists determining there was mental illness, would that affect your opinion? Can you explain to the jury what that does for your opinion?
It strengthens it. Again, it appeared that there was a psychotic disorder there, and so knowing that there had been earlier concerns or symptoms and a family history just adds to the likelihood that there is a psychotic disorder.
So when you say disorder, you're talking about an illness, right? And then, was it like you said before, and then a stressor can cause it to exacerbate into the symptoms that you saw?
Yes.
The symptoms you were seeing in large part appeared to be what are called positive symptoms.
Yes.
Can you explain to the jury the difference between?
Objection, Your Honor, it goes beyond the scope.
Ms. Brady, I think it does.
Okay, can I have just a moment?
Yes.
And prior to the psychotic break you described could be that prodrome stage you were describing before.
A prodrome state can occur for weeks to months to sometimes even years prior. It can be subtle findings. It can be people withdrawing, people developing odd beliefs, but that were not fully delusions, for instance. Multiple things can be prodromal symptoms, but again, they can last for weeks to months and kind of build up.
And escalate up to. Thank you.
Any follow-up questions from you, Ms. Pearson?
People who are in a prodromal state can function in society fine, right?
Typically.
And nobody would even be aware that there was anything going on with them because of their behaviors.
People tend to notice, so by having prodromal symptoms, you're demonstrating something. And so something is noticed. Commonly, people will start to withdraw from relationships. They will have some sign. So you're noticing something. You just can't quite put your finger on what it is yet.
But by and large, people are functioning okay at that stage.
Yes.
Thank you.
May this witness be released from our subpoena?
Yes, sir.
Any objection?
No, Your Honor.
All right, thank you.
Thank you.
All right, members of the jury, it's about 12:22. Today is a day when we have to finish a little early, so let's plan to end at 4:45 today, no later than 4:45. In light of that, is everyone okay taking a shortened lunch break? say, an hour and about 10 minutes, so I'll have you back at the usual 1:30, even though it's already 12:22? Does that present a problem for anyone? All right, and then let's plan on taking a shortened lunch break the rest of this week if we can. We're still ahead of schedule, but I want to make sure we keep us, or I keep us ahead of schedule, okay? All right, thank you. Please make sure you comply with all my admonishments during the break. The record should reflect the jury has exited the courtroom. Let's go ahead and take our lunch break, and I'll see everyone back here at 1:30. The court will be in recess. Thank you. Please be seated. Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Are the parties ready for the jury?
Yes, Your Honor, I think we are.
Okay, let's get him, please. Please be seated, everyone. The record should reflect that the jury's back in the courtroom. Welcome back, everyone. I hope you had a good lunch. Good. All right, call your next witness, please. Ms. Hicks.
Thank you, Your Honor. We call Deputy Laughlin.
This way, please. Good afternoon. Could I have you raise your right hand, please, so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, please be seated. Tell us your full name and spell your first, middle, and last names, please.
My name is Jacob Anthony Laughlin, spelled Jacob Anthony Lofland.
Ms. Higgs, you may proceed.
Thank you, Your Honor. Good afternoon, Deputy Laughlin. How are you?
I'm well.
Good. You work for the Arapahoe County Sheriff's Department, is that right?
Yes, ma'am.
Are you currently on patrol?
Yes.
Now, prior to today, back in July of 2012, were you working at the Arapahoe County Jail?
Yes, I was.
Do you recall what your assignment was over there at that time?
I was assigned to the infirmary at the jail,
The medical unit?
the medical unit, yes.
Do you remember what shift you were working over there at that time?
Swing shift. There was 2:30 to 12:30. I had Thursday, Friday, Saturday off.
So you worked Monday, Tuesday, Wednesday?
Sunday, Monday,
Sunday,
Tuesday.
Monday. I thought I was
Yes, ma'am.
missing a day. Thank you. Officer, do you recall in the late part of July of 2012 that Mr. Holmes came to be an inmate there at the medical unit? Is that right?
Yes, ma'am.
I just want to speak with you briefly about an incident that occurred related to Mr. Holmes on July 24th of 2012, okay?
Okay.
And I believe there was a point in time on that day that another inmate, not Mr. Holmes, brought a note to your attention. Do you recall that?
Yes, ma'am.
And can you explain to the jury what occurred?
Could I have my report to just reference to?
Let me ask you a couple questions, and
Okay.
yes, you will be able to.
Okay.
You wrote a report regarding that incident, right?
Yes.
Okay. Would looking at that report refresh your recollection as to exactly how things occurred
Yes.
with regard to that note?
Yes, ma'am.
Okay. If I may approach.
You may. And, sir, you can move the microphone so that it's closer to your mouth. That
Okay,
way
I
we
wasn't
can all
sure
hear
how
you.
close
Yeah,
it
you're good. Thank you.
So I'm handing you your report from that date. If you could just take a look at that, and then when you feel it's refreshed your recollection, go ahead and look up at me, please.
Yes, ma'am.
Did that refresh your recollection about this incident?
Yes, ma'am.
Okay. At some point on July 24th of 2012, did another inmate, not Mr. Holmes, bring some sort of paper note to your attention?
Yes, ma'am. It was one of the cleaners for the infirmary. He was cleaning up after lockdown, and he brought a note to me there was a slot in the window, and it was a note written by another inmate addressed to James Holmes. It said Holmes on it.
Okay.
It didn't say James Holmes. It just said Holmes.
All right. When you say this was a person that was part of the cleaning staff, is this an inmate that comes to the medical unit to help clean the jail facility?
I'm not positive if he came down to the medical facility or if he was a worker that was housed in the medical facility at the time. There were times where we had trustees come down to medical, but then there were also times that there are folks that didn't have, weren't able to go to general population, but they're able to work and have good time.
Okay.
They would work from the medical unit after lockdown.
Nonetheless, this person is an inmate that is helping clean the facility.
Yes, ma'am.
Now, I just want to ask you a few questions about the layout and where that person would be cleaning, okay?
Mhm.
So, without getting too specific, my understanding is that there are several cells within the medical unit for inmates, is that right?
Yes, ma'am.
Okay. And then there's also one cell area that is left open for the inmates to access when they have time out of their cell.
Yes, ma'am.
Okay. And then there's sort of like a common open space where someone would have access to the shower and that type of thing. Is that right?
Yeah, if you were to look at it, it's just an extra wide corridor with doors on either side, and there's phones at one end, the showers. That's kind of the common area. And then MC2 is one of the cells that's designated for the general population when they're out on their time, that there's a television in there and a seating area where they can watch TV and have their time out.
And when we're talking about timeout, we're talking about a limited period of time on a daily basis, I think for about an hour that they're allowed out of their cells. Is that correct?
Yeah, during that time, the minimum requirement was an hour.
Okay.
We tried to get everyone out longer than an hour,
Okay.
but the minimum requirement's an hour
Okay.
at the time.
So when you're saying that there was a person in there cleaning, are we talking about sort of the central corridor, the shower, and the common room?
Yeah, they don't clean, when the trustees come down or the trustee that works in that area cleans the cells, I mean, not the cells, the area, they do not clean the cells.
Okay.
They clean only the general hallway, corridor, the general area where they're allowed to, the inmates are on their timeout. They do not clean any of the cells except for MC2, which is designated as a public area for when they're on their timeout.
Okay. So this person brought you this note. Were you advised where this note was found?
Yes,
Okay, and where was that?
it was found on the desk in between the sitting area, in MC2,
Okay.
that general area where he was cleaning. It's just a note that was written.
You
I'm-
said it was addressed to Holmes,
Mhm.
correct? And do you recall what the note indicated?
Object to hearsay.
Your Honor, we're not offering it for the truth of the matter. We're just offering it for the fact that it was written.
All right,
We're happy to have an instruction for the jury.
would counsel approach, please? All right, the objection as to hearsay is overruled. Members of the jury, I am allowing evidence of the contents of this note, not for the truth of those contents, but rather for purposes of showing the effect on this witness, what actions this witness took as a result of becoming aware of the contents of the note, as well as the result, the effect of the contents of the note and the defendant when the defendant apparently learned about the contents of the note. All right? Does everyone understand that? Okay, and everyone's saying yes and nodding their head yes. Okay, Ms. Higgs, you may proceed.
So I believe, Deputy Laughlin, my question was something along the lines of, what did this note say?
So on one side of it, it said Holmes, in big letters. And the other side says, can I please get your autograph and draw me something? Just put it in the magazine and put it under the chair, please. I want to be the only one with it. Or give me your booking number.
Did it appear to you from the contents of this that another inmate was trying to have some communication with Mr. Holmes?
Yes, ma'am.
Did you then take some action as a result of reading this note?
I first reviewed the video.
Okay. And just so the jury's clear, when you're talking about the video, you go back and look at the surveillance video that you have of all the cells in the medical unit?
At that time, we had cameras in every cell, and we were able to go back into time, for lack of a better word, and review what had happened the previous hours before in MC2, where the note was found.
Okay. And what did you find out from the video?
We saw at about 7:20, according to my report.
Is that AM or PM?
7:20 p.m., 1920 hours. The note was found at 2328 hours, so that was 11:38. So at 7:20 p.m., we saw inmate Warren place a note on the table in MC2, and he did that. And at about 22:44 hours, which is 10:44 p.m., Holmes was on his timeout, and he read the note. He sat down in a chair. He always sat down in the chair, and this is when he wasn't in our facility for very long at all, but he would sit down in the same chair and watch television. And while he was sitting there, he reached over and opened the note. I don't know if he read it. It appeared that he read the note. And then he just put it back down in the same place and did nothing else with it. He didn't get up and draw a picture or sign it or anything like that. He just put it back down where he found it.
Seeming to kind of ignore the queries or requests within the note.
It appeared to be that he was not concerned what was in it.
Because you saw that he didn't respond to what was requested in the note, did you even bother to have any communication with Mr. Holmes about it?
No, I didn't. We didn't talk to Mr. Holmes about it whatsoever.
You did, however, speak with inmate Warren because this is not appropriate behavior, is that correct?
Yes, I did.
Just 1 minute, I think we might be done. Thank you, Officer is it officer or deputy?
Deputy
Deputy
Laughlin.
Deputy Laughlin, I appreciate it. I don't have
Either
any
way.
further questions for you.
Thank you.
Do you have any cross-examination, Mr. Edson?
Briefly, Judge, if I may. Good afternoon, Deputy.
Good afternoon.
Were you also assigned to the medical unit a few days prior to July 24th? So in that July 19th, July 20th time period, was that still your assignment?
I would have to see if those were my days off. But yes, I was assigned to it I had Thursday, Friday, Saturday off, and July 24th, 2012, I don't know what the day was on that.
Okay. Fair to say, though, you were assigned to the medical unit.
Yeah.
That was my question. Not
Yes.
necessarily if you were working on the night of the
Yes,
shooting,
sir.
but you were assigned to that particular area as of the night of the shooting, correct?
Yes.
So as of July 24th, fair to say that the defendant already had media interest. His picture, his allegations were already in the media. Is that fair to say?
Objection,
was.
Your Honor, I think this is outside the scope of direct examination.
Overruled.
And I also think that it's not relevant, and it's, yes, not relevant.
Overruled.
Go ahead.
Yes, he watched the news every night. It was on the media, yes.
Even in the medical unit or the infirmary as you described, do inmates have access to visitors?
Yes.
Just gonna have one moment, please.
Yes.
No further questions, thank you.
Okay. Is there any redirect?
Just briefly, Deputy, the camera that's in MC1 is, as you walk in the door, it's to the upper left, looking down into that room, is that correct?
I'm going to object beyond the scope of cross.
Sustained.
Your Honor, if I may approach?
Yes. All right, I understand where Ms. Hicks is going now, so the objection is overruled. Go ahead.
Can you repeat the question? I apologize.
Absolutely. When you walk into MC2, when you're standing at the door, facing that cell where the television is, on the right-hand side are the chairs, is that right?
Mm-hmm.
Is that a yes?
Yes.
Thank you. The camera is up on the left-hand side, looking down to capture that area of the room.
There were some, it's been over 2 years since I've been in that cell. It's, my vantage point is, from what I recall in the video, it's maybe upper left, maybe center of the door, because there's a box in the corner that were the old cameras, and then there's the dome cameras that were the newer cameras, and they weren't placed in the box, but I can't recall 100%.
So but it's up above the door?
Yes.
Kind of looking
in
sort of a little bit down and off into the cell, is that right?
into the cell, mostly, from what I remember, mostly seeing where the sitting area is, and just barely a little bit of the TV. You can see the light of the TV on, but you can't really see the TV playing. At the time of my vantage point, the camera angles get changed.
But that's what you recall that it was in July of 2012, is that correct?
Yes, ma'am.
So from that vantage point, from that camera, you would not actually be able to see what Mr. Holmes was watching on TV, but only that he's sitting there looking up at the TV, is that correct?
Yes.
Thank you. No further questions, Your Honor.
Right, is there any recross?
One moment, please.
So just so we're clear, as of July 24th, based upon your knowledge and your information, at the time that particular note was sent, the defendant was in the media, famous on a worldwide basis, correct?
Yes.
No further questions, Judge.
And there do not appear to be any questions from the jury. May this witness be released from his subpoena?
Yes, sir, he may. Thank you.
Any objection?
No.
All right, Deputy, thank you. Call your next witness, please.
We call John Henderson.
Good afternoon. Could I have you raise your right hand so that I can administer an oath? Do you solemnly swear or affirm on the penalty of law that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated. Please tell us your full name and spell your first, middle, and last names.
John Kenneth Henderson, John Kenneth Henderson.
Ms. Brady.
Thank you. Good afternoon, sir. Can you please tell the jury what you do for a living?
I'm employed as a criminal investigator with the Colorado Attorney General's office.
How were you employed on July 20th of 2012?
I was employed with the Department of Homeland Security as a federal air marshal assigned to the FBI's Joint Terrorism Task Force.
And as part of your work with the FBI on July 20th of 2012, did you interview a man named Jason Tregellis?
Yes, I did.
And was Jason Tregellis a professor at the University of Colorado at Denver for one of the classes that James Holmes attended?
I believe he said he was an associate professor.
Okay. And did Mr. Professor Tregellis tell you that Mr. Holmes did not seem to engage with the other students?
Objection, hearsay, request to approach.
Yes, please approach. Members of the jury, thank you for your patience. I appreciate that. All right, Ms. Brady, you may proceed as we discussed at the bench.
Thank you. Agent, did Professor Tregellis tell you that Mr. Holmes did not seem to engage with the other students?
That's my recollection, yes.
And did Professor Tregellis tell you that Mr. Holmes did not say much during class?
Yes.
Did he say that Mr. Holmes seemed to march to his own drummer?
Yes.
That Mr. Holmes displayed unusual mannerisms?
Yes.
And that Mr. Holmes was awkward?
Yes.
Your Honor, I would ask the court to read the instruction at this time.
All right, members of the jury, where a witness has made a previous statement that's inconsistent with the witness's testimony at trial, the previous inconsistent statement is admissible not only for the purpose of impeaching the testimony of the witness, but also for the purpose of establishing a fact to which the testimony and the inconsistent statement relate. Does everybody understand that? Yes? Okay. I'll read it one more time if you wish. Where a witness has made a previous statement that's inconsistent with the witness's testimony at trial, the previous inconsistent statement is admissible not only for the purpose of impeaching the testimony of the witness, but also for the purpose of establishing a fact to which the testimony and the inconsistent statement relate. All right, Ms. Brady, do you have any other questions for this witness?
I don't, thank you, Your Honor.
All right, Mr. Orman, do you have any cross-examination?
I do not. Thank you, Your Honor.
All right, and there are no questions from the jury. May this witness be released from his subpoena?
Yes, sir, thank you.
Any objection, Mr. Orman?
None, Your Honor. Thank you.
All right, sir, thank you.
Thank you.
Call your next witness, please.
Thomas Triska?
Good afternoon. Good afternoon. Do you solemnly swear or affirm in the penalty of law that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Deputy, you've testified before, but just to refresh everyone's memory, why don't you please state your full name and spell your first, middle, and last names?
Tom Triska, Tomtriska.
Good
Mr.
afternoon,
King?
Deputy.
Sorry.
Thank you, Your Honor.
Go ahead.
Good afternoon.
Good afternoon.
Thank you for your patience, sir. In your previous testimony, you testified, I'm just trying to cut to the chase here, that you were, I guess, the lead deputy assigned with bringing Mr. Holmes to his first few court appearances back in 2012. Is that right?
That's correct.
I want to turn your attention to the first court appearance, which was on July 23rd, 2012. Were you assigned to the Court Services Division in that capacity at that point in time?
I was.
And did you bring Mr. Holmes to court?
I did.
Who did that with you that day? Do you recall? And if you need to see your report, I'm happy to provide it for you.
No, I don't need to see it. Deputy Hall, Hall, was with me that day.
Was he in some kind of training at that point in time?
I think, if memory serves me right, I think it was his second day off of training.
And where did you go to pick up Mr. Holmes to bring him to court that morning, and what time was it?
We went down to the medical unit. He was located in MC1. We went down there 8:45.
Okay.
For his court hearing, so probably about 8:45.
And what do you do when, and MC1, and the jury's heard about that, is the cell, that first cell that's actually the cell he lived in, is that right?
Correct.
Do you actually go into MC1 to talk with him, or what do you do?
I did.
And where was he when you went in?
He was located on his bunk.
Did you give him instructions as to what was going to happen and what you were doing there?
I did.
And what did you need to do in order to get him ready to go before you could leave the cell to go to court?
Basically, I asked him to stand up and remove his red shirt. Asked him to put on a white T-shirt that we provided. We put on a ballistic vest, and we had him then place his red shirt back over that. And I gave Mr. Holmes instructions that I needed him to face the wall, Deputy Hall then placed the leg restraints around his right ankle, then his left ankle. And then we instructed him to turn back around and face us, and we put the body belt, basically the handcuffs on his right hand and then his left hand, secured the belt, and then basically gave him instructions on what we needed to do for there.
Were you observing him during the period of time that you were conducting this pat-down search and getting him dressed up to go to court?
I was.
And do you recall observing whether or not Mr. Holmes had a hard time standing on his own during that period of time?
Yes.
And do you recall whether or not you observed that Mr. Holmes' eyes appeared to wander off as you were talking to him?
I did.
Did you, during that period of time before you left the medical facility, become aware of whether or not Mr. Holmes was on any medications that you needed to be concerned of when you escorted him to court?
I asked the deputies that were down in the medical unit if Mr. Holmes was on any medications. They replied no. And at that time, I wasn't aware of him being on any type of medications.
Up to this point in time, was Mr. Holmes compliant with your commands and instructions?
He was.
And aside from the observations that you made, anything significant about this interaction in your mind?
No, sir.
What did you do after you got him suited up there?
Basically, we escorted him down what we call Main Street, and we took him down through the main part of the tunnel, brought him over to the courthouse, secured him in a whole cell until basically he was ready to come into court.
Okay. And during this period of time, did you continue to observe his demeanor?
I did.
And did you observe whether or not his eyes continued to wander and whether he continued to appear confused?
I did, and I would say that he remained in that capacity.
Okay. At some point, did you become aware that Ms. Brady and I, first of all, was Ms. Brady and I present at that court hearing?
You were.
And did you become aware whether Ms. Brady and I were requesting a brief opportunity to speak to Mr. Holmes before he was brought into court?
Yes.
And what did you do as a result of that request?
Sergeant Morris instructed me that the both of you would like to speak to him. We took him back to a jury room where you guys were, and we brought Mr. Holmes in and allowed you to talk to him prior to bringing him into the courtroom.
About how long did we talk to him?
10 minutes.
Did you overhear the conversation? Were you eavesdropping on our conversation?
Sir.
Was it after that you took him into the courtroom, sir?
I don't remember if we took him back to the whole cell or if we brought him immediately into court, but it was shortly one after the other.
Okay. And when you brought him into the courtroom, was the courtroom, first of all, was it this courtroom?
It was.
It was. And do you recall whereabouts you brought him in to be seated?
I do.
Where was that?
We brought him in the door to my left, and we had him had a seat in the very first chair closest to us in the jury box.
Okay. And where did you then position yourself? Were you where the sergeant is now, approximately, or?
Approximately, yes.
Okay. And was that in order to keep an eye on him and the proceedings?
Correct.
And for the record, your purpose there is to provide security. Is that right?
My role that day was specifically him.
Him.
Yes.
Okay. And that was why you were paying such close attention to him, fair to say?
Right.
During this period of time, when he was in the courtroom, did you continue to observe his behavior and demeanor?
Yes.
And did he continue to appear confused, sleepy at times, and his eyes wandering?
Yes.
Sir, have you had I'm going to ask to approach the witness if I may. I'm showing counsel what I've marked as DTR-83.
Okay,
May I approach the witness with DTR-83?
yes.
Sir, I'm handing you 83. Do you recognize that?
I do.
And is that a DVD of that first court appearance?
It is.
Have you reviewed that, sir?
I did.
And did you see yourself and Mr. Holmes and Ms. Brady in that court appearance?
I did.
And did you initial that today after you reviewed it?
I did.
Did that appear to be a fairly accurate representation of Mr. Holmes' demeanor during that period of time when he was in the courtroom at least?
Yes.
Judge, I'd move the admission of DTR 83.
Is there any objection?
Mr. King and I discussed that that would be a version that had no sound on it. He told me that's the case, I'm assuming that's the case, so I don't object to it, assuming that's the case. If they mix something up by accident, I don't want to waive my objection in case it does have sound on it.
All right, it doesn't have any sound, Mr. King?
Yes, Judge, that's correct, and I can clear that up with the deputy if you'd like me to do that.
That's
but-
okay, that's all right. I'll take
No,
your word
this
for it.
version has any sound is removed from it.
Okay, all right. Without objection, then D-TR-83 is admitted and may be published.
And I have no more questions for the Deputy Triska. I have no objection to publishing the exhibit now or following the cross-examination either way.
Okay, Mr. Orman, do you have a preference?
I think I'd prefer to cross after it's been published, Your Honor.
All right, let's go ahead and publish it then. Do you want me to dim the lights?
Yes, please, sir, and I think this is a little over 11 minutes long.
Okay. Okay, the record should reflect that we just finished playing D-DR-83. Mr. Orman, cross-examination.
Thank you. Deputy, first I want to ask you about that video, and then I want to ask you some other questions. Then I'll probably come back to the video. When that was recorded, was the camera that was recording that visible in the courtroom?
It was.
Was it in fact like a big TV camera from like a TV station on a tripod over here?
Yes, sir.
And by over here, sort of motioning towards the front of the gallery on the left-hand side as you would face the judge?
Correct.
Do you know whether or not the defendant was wearing his contact lenses when this was happening?
That day I did not.
This happened on the morning of July 23rd, correct?
The court appearance?
Yes.
Yes, sir.
What we just saw on
Yes.
the video. And was that a Monday?
Sounds right.
All right. So does it sound right that he was arrested in the early morning hours of July 20th?
Correct.
So then evening of July 20th, do you know how many hours of sleep the defendant actually got?
No, sir.
And even if he'd been lying in bed, he might not have been sleeping, correct?
Speculation.
It's proper lay opinion, Your Honor.
Overruled.
Correct. I would have no idea.
And let's talk about then the 21st. Do you have any idea how much sleep the defendant got during the day, the evening, or any time on the 21st of July?
No, sir.
How about the 22nd, the night before? Do you have any idea how much sleep the defendant got on the 22nd or during the day or the evening or any time on the 22nd?
No, sir.
And then the early morning hours of the 23rd, before the defendant was woken up by you, and did you wake him up?
No, sir. He was awake when we got there.
Okay. Well, before he woke up, do you know how much sleep he would have gotten the morning of the 23rd?
No.
Right, so do you know if he got any sleep at all from the time that he was arrested until the time he was brought into court?
I have no idea.
But you did notice that he appeared sleepy, correct?
Correct.
In fact, you wrote an official police report where you put in there you thought he looked sleepy, right?
I did.
Have you seen people in the past that have gone without sleep?
Yes.
In relevance.
Overruled.
Did the defendant appear to you to be in a state where he probably hadn't gotten a lot of sleep?
Objection asked and answered.
Overruled.
Yes.
In that video, does he also appear upset and sad?
I don't know if he was upset or sad. I think that
Objection to any speculation, Your Honor.
He's answered the question. I don't know what else he was gonna say, so. He's answered the question. You should ask the next question.
Thank you. Would it be natural for a person in the defendant's position to have a lot on their mind at that point in time?
Objection. Lack of foundation calls for speculation.
Sustained.
May I approach, Your Honor?
Yes. Okay, Mr. Orman, you may proceed as we talked about at the bench.
Thank you. Would it be natural for a person who was facing 12 counts or potentially 12 counts of murder and brought into their first court appearance to have a lot on their mind?
Yes,
When you were interacting with the defendant, did he appear to be responding to things that were not there?
no,
In other words, did he appear to like answer questions from voices and people that were not actually speaking?
no,
When you asked him to do something, did he react appropriately?
he did.
For instance, when you said, put on this shirt, did he put on the shirt or did he respond by saying, well, that's a basset hound and I can't put that on?
He complied with what I asked him to do.
Can I have a moment, Your Honor?
You can.
That concludes my cross-examination. Thank you, sir.
All right, Mr. King, do you have any redirect?
Briefly. Deputy, are you sure he didn't say anything about a basset hound?
I'm positive he didn't say anything about a basset hound.
You're not a psychiatrist, are you? You're a psychologist?
No, sir.
You weren't inside Mr. Holmes' head, were you?
No, sir.
You don't know what he was thinking or what he was seeing, do you?
No, sir.
You don't know if he was responding to internal stimuli or voices or seeing things, or you don't have any idea what was going on inside his head, do you?
I don't.
All you know is what you observed. Is that right?
Correct.
No other questions.
Is there any recross?
Thank you, Your Honor. What you observed, sir, was that he was responding to your questions appropriately, correct?
Correct.
And what you saw was that he was responding to your commands and directives appropriately, correct?
Correct.
And what you saw was that he was not responding to voices or people or things that were not there, correct?
Calls to speculation.
Overruled?
Is that right?
Correct.
Thank you, Your Honor.
All right. The jury does not appear to have any questions for this witness. May this witness be released from his subpoena, Mr. King?
Yes.
All right. Any objection, Mr. Orman?
I don't, Your Honor.
All right. Sir, thank you. Members of the jury, it's 5 till 3. Let's go ahead and take our afternoon break. Please keep in mind all my admonishments. They all apply during the break. I'll see you back here in 20 minutes. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Is there anything we need to talk about before our break? Please, thank you. All right, we'll be on break. I'll see you in 20. Thank you. The court will be in recess. Please be seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Let's bring the jury in, please. Please be seated, everyone. The record should reflect the jury's back in the courtroom. Ms. Brady, please call your next witness.
Your Honor, we would call Patrick Herr.
Good afternoon. Could I have you raise your right hand? Solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Please be seated. Can you tell us your full name and please spell your first, middle, and last names?
Patrick, Patrick, William, William, Herr, Herr.
Ms. Brady, you may proceed.
Thank you. Good afternoon, Mr. Herr. Can you please tell the jury where you were working in November of 2012?
I was working for Action Care Ambulance in Centennial.
And what did you do for Action Care Ambulance?
I was a paramedic.
Do you recall being dispatched to the Arapahoe County Jail on November 13th of 2012?
I do.
Can you tell the jury what you remember about that call?
The entire call, or
What did you believe you were going to the jail for?
we were dispatched for an unknown medical emergency.
And when you got there, were you given a little more information about the nature of the call?
Yes,
What information were you given?
that Mr. Holmes was involved in some behavior over the weekend. He was not eating, not drinking, banging his forehead off of the wall and falling off of the bed backwards.
Anything about whether he was interacting with staff as much as he had been before? Do you remember anything about that?
His interaction with the staff there was reported that it had been decreasing throughout the weekend.
Decreasing?
Yes.
And what was the jail asking you to do?
To evaluate him and transport him to Denver Health for a CAT scan.
All right. Can you tell us what you observed when you first met Mr. Holmes?
He was standing, they walked him out of a solitary confinement cell, I'm guessing. And he had a vest, almost like a lead type, I guess the best way, like an X-ray type vest. And it's the first time I've ever seen him when they called it a suicide vest. And underneath that, he had some sort of a flak jacket as well. I'm not sure exactly what it was, but
And when you say they escorted him out, who do you mean?
the prison guards.
Okay. Go ahead.
He had a very flat affect and appeared disheveled and parched.
Parched? Okay.
Yes.
Did you try and speak with Mr. Holmes?
Yeah, I made the first interaction with him.
And how was it? How was he at responding to you?
He smiled and did not respond verbally.
Okay. What kind of a smile was it?
It was a large smile, just teeth showing and very wide.
Was he responding to you at all verbally?
No.
Were you trying to ask him questions to sort of assess his condition?
Yes.
Was he taken to the ambulance?
He was taken to the ambulance.
How did he get to the ambulance?
On a stretcher.
And were you in the back of the ambulance during the ride or not?
I was not in the back.
What was your role?
I was the driver.
All right. Were there any assessments done of Mr. Holmes where he was asked to repeat something?
There was a neurological assessment for a Cincinnati stroke scale.
And what does that involve?
Looking for a unequal smile, any slurred speech, and any unilateral extremity deficits.
And was he asked to repeat a certain phrase?
He was asked to.
And did he do that?
He did.
And did you note any slurred speech?
No.
Did you note something else unusual, though?
The speech that we asked him to repeat, he repeated it repetitively throughout the course of the trip.
Did you tell him to keep repeating it?
He did not.
And what was that phrase?
You can't teach an old dog new tricks.
While you were the driver of the ambulance, could you still hear what was going on in the back of the ambulance?
Yes.
During the trip to the hospital, could you hear Mr. Holmes repeating that sentence?
Yes.
Could you hear any other noises coming from him?
He would moan occasionally.
Do you know whether any medical procedures were performed on Mr. Holmes in the back of the ambulance while you were driving?
None that I know of while I was driving.
Was he given an IV at any point in the ambulance?
He was.
Right, and what was that for?
To give fluid for dehydration.
And who was the paramedic who was in the back of the ambulance with Mr. Holmes during this trip?
Paramedic Jeremy Leadham.
And which hospital did you take Mr. Holmes to?
Denver Health.
And what happened once you got to the hospital? Where was Mr. Holmes taken?
They have a sally port behind the hospital, I think off of Bannock, that goes down into a holding area for emergency department for prisoners. And we took him through the double doors and into a hallway there.
And did you go with Mr. Holmes during his trip into the hospital?
I did.
When you got to Denver Health, was he still repeating the phrase, "You can't teach an old dog new tricks"?
Occasionally, yes.
Can you estimate over what period of total time did Mr. Holmes repeat that phrase?
I don't, I can't, I mean, an hour and a half maybe.
Did Mr. Holmes ever make eye contact with you?
Yes.
Did he ever speak to you?
Not verbally, no.
Do you know how much fluid he got from the IV on the trip to the hospital?
500 milliliters.
Did you see any injuries to Mr. Holmes's head?
I did.
What did you see?
Hematoma on his forehead.
What is a hematoma?
It's a bruise, blood pooling under the skin.
Could you tell whether it was raised at all?
It was raised.
And approximately how big do you think?
It's approximately golf ball sized.
Golf ball size?
Yeah.
Your Honor, can I have just a moment?
Yes.
Thank you, Mr. Hurd. The district attorney might have some questions too, okay?
Okay.
Mr. Edson, do you have any cross-examination?
I do not. Thank you, Judge.
All right. And the jury does not appear to have any questions for this witness. May this witness be released from his subpoena?
Yes, sir.
Any objection?
Thank you, sir.
All right, sir, thank you. Call your next witness, please.
Russell Martins.
Okay. Good afternoon. Can I have you raise your right hand so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Tell us your full name and spell your first, middle, and last names.
My name is Russell Henry Martins, Russell, Henry Martins.
Mr. King?
Thank you, Your Honor. Good afternoon, sir. How are you?
Good. Good afternoon.
What do you do for a living, sir?
Currently, I work for Laramie County Sheriff's Office, Cheyenne, Wyoming, as a mental health counselor.
Okay. And did you previously work for the Arapahoe County Sheriff's Department?
I did until January 1st of this year.
And in what capacity did you work there, sir?
My job title is classification specialist.
Okay. And what is a classification specialist in the context of the Arapahoe County Detention
In
Facility?
Arapahoe County, we determine housing, as well as we are the frontline mental health team.
Okay. And do you have what's your degree in?
I have a master's in clinical psychology.
And does that assist you in assessing the medical and psychiatric needs of inmates?
The psychiatric, yeah, not the medical.
I want to direct your attention to 2012. Did you work in the detention facility here at that time in that capacity?
I did.
Do you recognize Mr. Holmes, who's seated over here?
Yes, I do.
And did you have some contact with Mr. Holmes during the early part of his incarceration?
I did.
And what was the purpose of your contact with Mr. Holmes, just generally speaking?
Just generally checking assessment of, since I was in charge of housing and mental health, just checking on him on initially a daily basis, checking on his safety.
I have for you, if you need it, sir, copies of the chart, which includes your notes from that period of time. If you need to refer to those, just let me know. May I approach Judge and just give them these in case he needs them?
Yes.
Please.
Oh, sure.
Thank you.
I want to ask you some questions about some specific contacts that you had with Mr. Holmes, both early on in his incarceration, like late in July and early in August of 2012, and then in November of 2012. Is that acceptable with you?
Absolutely, yeah.
The first questions that I have involve your notes from July 29th, 2012. And this is page 65475 of Discovery for Counsel. On that time, at about 11:09 a.m., did you see Mr. Holmes at that point in time?
Yes.
And what was the purpose of meeting with him at that time?
Just assessing for his needs.
Okay. And where did you meet with him?
In his cell.
And is that MC1 cell that we've heard about down in the medical unit of the detention facility?
Correct.
And when you went in, what was Mr. Holmes doing, if you recall? Was he standing there, seated?
I believe, according to my notes, that he was laying down.
Okay. And how did he kind of present to you at that point in time? What first of all, what kinds of questions or topics would you be talking about him or another inmate in that situation with at that point in time?
Just refer to my note real quick.
Absolutely, feel free.
Looks like I just had a basic conversation of, did he need anything? Or did he have any questions? Was there anything he'd like for me to answer? Would he like to meet me later in the day?
Is that a common thing that you would do for someone who is newly incarcerated?
Typical, yeah.
Okay. And how did he present to you when you went in to talk to him about that? What was his manner of presentation, if you will?
Nothing out of the ordinary that I recall or that I wrote down. Just a casual conversation. Looks like he was concerned about somebody that was perhaps yelling on the same side of the MC area. Apparently he'd heard somebody yelling earlier.
Okay. Someone yelling for help or?
Yeah.
Okay.
If I recall it, based on this note, maybe another one, I believe there's some guy person detoxifying off of alcohol. So
Sure. When you talked to him, did he present to you as dismissive with a flat affect? Do you remember that?
Into the leading nature of the question.
Sustained. And sir, if you would pull the microphone closer to you, please, to make sure we can all
Sure.
hear you. You can move the microphone. There you go.
Okay. It looks like I did, yeah.
Hold on, there's no question yet.
Oh, sorry.
Go ahead.
How did he present to you when you asked him had this discussion with him? What was his manner of presentation to you?
Looks like he presented with mostly a flat affect.
What does that mean based upon your experience and training as a mental health professional?
Non-emotional. So he didn't express himself emotionally in any way.
Okay.
So no anger, no sadness, no, just nothing.
Anything else that you recall about that encounter that stood out in your mind?
Not that I recall.
Okay. On the 31st of July, you had another, you had a conversation, I think, strike that. It looks like a conversation with someone from the jail staff, so I won't ask you about that. On the 31st, though, you did again go in to assess Mr. Holmes. Did you do that on that date as well, the 31st of July, 2012?
Yes.
And when you asked him how he was doing, did he respond affirmatively, or?
He did. He said, I asked him how he was doing. He said he was good.
Okay. Was he oriented ×3, if you know?
He was.
Okay, and what does that mean?
He knew where he was, he knew who he was, and he knew the date, time.
Okay. How do you assess that? Just by asking?
I asked those questions.
What did you notice about his eye contact? Did he make eye contact with you?
He had good eye contact. So he just had normal eye contact with me. So when I looked at him and I asked him questions, he just continued that. He didn't turn away or just a normal conversation.
Did he or did he not at times look upwards and pause prior to answering some of your questions?
He did.
Was he talkative with you? I mean, did he answer your questions with narrative responses, or did he just basically answer yes or no to the questions you asked him?
I think in this particular case, there wasn't a lot of yeses or nos. There were some statements. So he answered in sentences, I guess, in this case.
Okay.
Looks like. Oh, I wrote. Inmates' responses are mostly yes or no. So, okay.
Are mostly yes or no, is that right?
Correct.
And so, I'm going through your notes here, so, when we get to, does it also indicate that whether or not Mr. Holmes was polite and cooperate, but did not initiate any questions?
Correct, yes. He was polite and cooperative.
Okay. On the 1st of August, did you again meet with him to assess his needs?
I did.
And was it a similar type of situation where he had no specific questions or concerns?
Yes.
Was there a time during November of 2012 when there was a change, at least from your perspective, a change in the demeanor of Mr. Holmes? And I'm talking about mid-November 2012, if you remember.
Yes. I'm looking for the note, but yes.
It's 11/11. It's the first note, I think. Did you find that? I think they kind of go backwards in time.
I have 11/13. No. 11/12.
I can help here.
There it is, 11:11.
Thank you. Was that at 12:02?
Yes,
Would that be 12:02 in the afternoon or in the morning?
that would be the afternoon.
Okay.
That's when I wrote the note,
Okay.
at least.
Did you then see Mr. Holmes to assess his needs at that point?
I did.
And was he inside MC1, his normal cell, or was he inside a BC cell on the other side, the rubber cells?
He was in one of the rubber cells, BC5.
Okay. And what were you assessing him for at that point?
He was placed on a suicide watch. I was assessing him for needs, whether he's suicidal.
Okay. Did you ask him why he was on suicide watch, if he knew why?
I did.
Did he know why, or how did he respond?
He responded, "I'm scared of what I will do."
Okay. Did you ask him to explain that?
I did.
And what did he say?
I'm trying to keep it all together.
Did you say, I'm trying to keep it all together?
Correct.
Okay. And did you ask him to explain that further?
I did.
And what did he say?
He said the system, all the systems.
When he said the system, all the systems, did you ask him if he felt like that was a lot for one person to do?
I did.
And did he respond?
He did. He said yes.
Did you ask him why he had fallen back in his cell?
I did.
And how did he respond?
He said, "I do not know that you are real."
Now, when he said to you, I do not know that you are real, how did he appear to you based upon your experience and your...
He appeared authentic and showed what appeared to be fear or nervousness based on his facial expressions and trembling voice.
At this point in time, did you ask him how you could help to understand if you were real for him?
I did.
And what did he say?
He said, "If you shook my hand."
And did you explain that that wouldn't be permitted by the deputies under those circumstances?
I did.
Could he answer any questions at that point in time so you could determine whether he was oriented ×3?
No.
The next note I would like to refer you to would be just the next day, sir, on the 12th of November, 2012 at 11:53.
Okay.
Did you again assess him in BC5?
I did.
And what was his condition when you saw him there?
He was laying naked on his left side near the door.
And what did you do, if anything, sir?
I asked him what we could do to help him.
And what did he say?
You could give me water.
Did you ask him if he was thirsty?
I did.
And what did he say?
He said, "I don't know where the water is."
At that point in time, did he present as confused and seem to have difficulty responding to questions?
Objection leading.
Sustained.
Did he appear to be confused to you, or did he not appear to be confused?
He appeared to be confused.
Did he appear to have difficulty responding to questions, or did he not have difficulty responding to questions?
He appeared to have difficulty responding to questions.
May I have a moment, Your Honor?
You may.
That's all I have for now. Thank you, sir.
Cross-examination, Mr. Orman.
want to ask you now about some of the dates that Mr. King asked you about, and I think at least one where he did not. So let's talk about that first date that you discussed on direct examination, July 29th, 2012. And I think the note that you wrote, you at least wrote it at around 11:09 a.m. Would it help you to refresh your memory to just take another quick look at that?
Sure.
May he do so, Your Honor?
Yeah.
So why don't you just take a look at that, then I'm going to ask you some questions about it.
Okay.
So when you started the conversation with the defendant, this was in his cell, is that right?
Yes.
And you started talking to him, he asked you, are you Russ? Correct?
Yes.
And is that the name you go by, Russ?
Yeah.
And did people in a jail call you that, or do they call you your last name?
Russ.
So somehow he knew your name was Russ and was able to ask you if that was your name.
Correct.
Then he asked you, does everybody meet with classifications, correct?
Correct.
And, well, does everybody meet with classifications?
Yes, eventually.
And you mentioned when Mr. King was asking you questions that he apparently had some thoughts about another person who had been yelling in the pod. Do you remember that?
Yes.
And is that the right word, pod?
No, we wouldn't consider that a pod. I guess we just consider that medical housing.
The unit, would that be?
Would be good.
All right. So, and he asked you specifically, did you help that person who was yelling for help? Is that
Yes.
right? And this again was July 29th.
Correct.
And then he explained that this person had been yelling a couple of days ago. Is that right?
Correct.
When you had this conversation with the defendant on July 29th, he had good eye contact with you, right?
Correct.
But you mentioned a flat affect, right?
Yes.
That means like not emotional?
Yeah.
But at the same time, he appeared at least to be annoyed with you, correct?
Yes, that's what I wrote.
And dismissive of you.
Yes.
Again, that was on the 29th, correct?
Correct.
You told him to contact deputies if he had any questions or concerns. And did he indicate that he would do that if he needed to?
I don't recall.
Let's go to July 31st. And it looks like on that date you have two notes that you wrote, one from 2:37 p.m. and then another one from 2:52. Would it help you to remember what happened when I ask you questions to take a look at those first?
Yes, please.
May he do so, Your Honor?
Yes.
Just take a look and tell me when you're done reading.
Okay. Okay.
So on that date, first, let's go to the later note, which sort of goes back to something a little earlier. He had escorted by court deputies, you saw, and returned from court without incident, correct?
Correct.
And then also on July 31st, you had a conversation with him to assess his needs, and you asked him if he had any, and he said he didn't have any needs or questions for you, right?
Just as a clarification, that was a late entry note.
Okay.
It's actually the day before from 7:30.
Okay, so, all right, so the first thing I asked you about was the day before,
Correct.
the coming and going to from court.
Correct.
This, what I'm asking you about is actually the 31st.
Okay.
Is that right?
Correct.
All right. So you asked him if he had any needs or questions, and he told you that he did not, correct?
Correct.
And you asked him how he was, and his response to you was good. Is that right?
Correct.
And again, he had good eye contact with you, but sometimes would pause before answering a question and maybe look up and then answer the question.
Correct.
But he was able to answer your questions, correct?
Yes.
And he smiled at you on July 31st, right?
Yes.
You had a conversation with him about how, if he was aware of whether or how he could request books from the library through the kite system, right?
Yes.
And he indicated that he was aware of that.
Yes.
He was able to answer that question.
Yes, he was.
He actually was able to tell you that he knew that he had a court date coming up that Friday, right?
Yes.
And although he would generally answer questions yes or no, if you asked him an open-ended question, he would give an open-ended or appropriate response, correct?
Yes.
You asked him how much he was sleeping, and he essentially said, well, I need a timer to figure that out, right?
Yes.
Is there a clock in that cell?
No.
Is he allowed to have a watch?
No.
He was polite and cooperative with you, correct? Is that a yes? I didn't hear
Yes,
you. I'm
yes.
sorry. And you asked him if he had any other concerns. He said no, correct?
Correct.
But he did indicate that he knew how to use the kiosk system to make any requests, correct?
Correct.
I would like to go to August 1st of 2012, and just for your reference, I believe the time of the note that you wrote is 3:23 p.m. Do you have that?
Yes.
Would it help to answer my questions and remember if you could take a look at that first?
Yes.
May he do so, Your Honor?
Yes.
Tell me when you're done.
Okay. I'm done.
So at some point on that date, you asked him how his day was going, and his response to you was doing good.
Yes.
You commented to him that he was not much of a talker because he would answer questions generally yep or no, right?
Correct.
And his response to you was that sometimes he is a talker, correct?
Correct. He said sometimes I am.
You asked him if he felt suicidal on that date, August 1st, and he said he did not, correct?
Correct.
The next date I want to ask you about is August 14th of 2012, and it looks like the note that you wrote on August 14th is at 1:46 p.m. Do you have that?
I do.
Would it help to answer my questions if you could read that first and refresh your memory?
Yes.
May he do so, Your Honor?
Yes.
Go take a look and tell me when you're done.
I'm done.
So on this date, you see him typing at that kiosk system, correct?
Yes.
Now, where's that kiosk system in relation to his cell?
I guess leaving his cell, it's probably 15, 20 feet to his right on the opposite wall,
Now, he doesn't just have access to this all the time, right?
just when his door is open
Is that called the timeout?
during his timeout.
And he was sitting there or standing there. How does that work? Is there a chair or do you stand up?
Either, I don't recall whether he's sitting or standing.
So you saw him at the kiosk and you asked him how he was doing. He said he was doing okay.
Correct.
You asked him if he needed anything. He said no.
Correct.
And he had the same usual affect that you'd seen him with before, correct?
Correct.
He had a professional visit and then was brought back without incident.
Correct.
And this again is the 14th of August, correct?
Correct.
And you indicated you had a discussion with him that he would send a kite if he needed anything else, correct?
Correct.
Now, I asked you about one of these notes where you had asked the defendant if he was suicidal. Did you ask him that on a regular basis?
Yes.
And did he ever tell you he was suicidal?
No.
Can I have a moment, Your Honor?
Yes.
I don't have any further questions on cross-examination. Thank you.
All right, is there any redirect?
There is not, thank you.
All right, and the jury does not appear to have any questions for this witness. May he be released from his subpoena?
If you may.
Any objection?
None, Your Honor.
Sir, thank you.
Thank you.
Call your next witness, please. Good afternoon. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes, I do. Please be seated. Please tell us your full name and spell your first, middle, and last names.
It's Craig, C-R-A-I-G. I'm sorry, do you want a middle name too?
If you have a middle name.
Yeah, it's Galen, G-A-Y-L-A-N. Last is Clark, C-L-A-R-K.
Good afternoon, Detective Clark.
Afternoon, ma'am.
Where do you work?
Arapahoe County Sheriff's Office.
Okay, and have you testified in this trial before?
Yes, ma'am.
How long have you been with the Arapahoe County Sheriff's Office?
15 years.
And are you a detective and a member of the Arapahoe County Sheriff Office Bomb Squad?
Yes, I am.
Okay. What I'd like to do is I would like to move to the early morning hours of July 20th. Did you go to the theater?
I did.
Okay. And in your capacity as a member of the bomb squad, did you and a team work on a white Hyundai outside of the theater, Mr. Holmes' car?
Yes, ma'am.
Okay. And did you operate the robot that was used to process or interrogate that car?
I did.
I want to just talk to you specifically about getting into the trunk or the hatchback of that car. Did you have to use the car key in order to open that trunk or hatchback?
Yes.
Okay. And to do that, did you have a member of your unit go over to the car and pull a set of keys off the roof of the vehicle or the top of the vehicle?
Yes.
Okay. And then did that member of the bomb squad then put that key from that set of keys or put a key from that set of keys into the lock of the trunk?
Yes, he did.
Okay. And then did you use the robot arm to actually turn that key?
That's correct.
And you were able to turn the key and you were able to unlock the vehicle?
That's correct.
Now, in the process of doing that, was that key damaged?
I believe it was bent a little bit.
Okay. And so if there is on that set of keys a single key that's misshapen, that was the result of the work that you did using the bomb robot?
Yes, ma'am. I haven't seen the key since, so I didn't see it after the fact, but I would agree if there's a key that's bent, that would have been from the robot.
Okay. And is that because of the weight of the trunk and the use of the robot arm in order to unlock the key?
No, it wouldn't be from the weight of the trunk. It was just the twisting on the arm. If it wasn't 100% square with the locking mechanism itself, that it would probably bend it at that point.
Okay. I may have a moment.
Yes.
That is all I have.
Okay.
Any cross-examination?
And Investigator Clark, to be clear, you haven't seen the keys and you don't recall whether in fact there even is a bent key, is that right?
That's correct.
And with regard to the robot, it's trying to manipulate a key with what amounts to big metal pincers, correct?
That's correct.
So if it would be bent in some process of that, that would simply be because it's a difficult job for a robot to do.
Yes, ma'am.
Do you have any redirect?
No.
And there are no questions from the jury. May this witness be released from his subpoena.
No objection.
Any objection?
No, Your Honor.
All right, sir, thank you. Call your next witness, please.
Your Honor, we call Angela Benford.
Good afternoon. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Please tell us your full name and spell your first and middle and last names.
Angela Jean Benford, ANGELA JEAN BENFORD.
You may proceed.
Thank you. Good afternoon.
Afternoon.
Is it Investigator Benford?
It is.
Okay. And you've previously testified?
I have.
Okay. And you are a crime scene investigator with the Aurora Police Department?
Yes.
How long have you done that?
17 years.
Okay. I want to just draw your attention to the work that you did processing Mr. Holmes' vehicle following his arrest.
Okay.
Now, you and another crime scene investigator went to Mr. Holmes' car, processed the car, searched the car on August 3rd of 2012. Is that right?
Yes, we did.
Okay. And you previously testified about some of the items that you found inside the car, like some, like 2 magazines and some cartridges. Is that right?
Correct.
Okay. And what I want to do is I want to talk to you about an item that was found that was photographed but not collected.
Okay.
And I'm going to approach with what's been marked as Defense Exhibit 84. If I may approach the witness and I'll show the prosecution the exhibit.
Yes.
Investigator Benford, are you familiar with that photograph?
Yes, I am.
Okay. And does that photograph reflect several of the items that were found originally inside of Mr. Holmes' car that were photographed?
Yes.
Okay. And is that an accurate representation of those items?
It is.
Okay. Judge, I'd move for admission of Defendant Exhibit 84.
Any objection?
I don't object, Your Honor.
Without objection, it is admitted and it may be published.
Thank you, Your Honor. If we could please publish 2226. Now referring to Defense Exhibit 84, I want to draw your attention, and if we could call out the brown box labeled black and mild. Now, this is one of the items found in Mr. Holmes' vehicle. Are cigarellos, is that the name on the box?
It is.
Okay. And are those like little cigars?
Correct.
Okay. And looking at the call out or looking at the photograph, does that package of cigarellos, does that appear to be a full pack or partial pack?
It appears to be a partial pack.
Meaning some are missing?
Yes.
I have no further questions.
Is there any cross-examination?
Thank you.
Oh, Your Honor, thank you.
All right. May this witness be released from her subpoena?
She may.
Okay. And for the record, there are no juror questions. Any objection to her being released from her subpoena?
No, Your Honor. Thank you.
All right. Thank you, investigator.
Thank you.
Call your next witness, please.
Your Honor, the defense calls Detective Gordon Madonna.
Good afternoon. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes, I do. All right, please be seated. I know you testified before, Detective, but if you could tell us your full name again, and if you don't want to use your middle name, you can use your middle initial again. I know you're sensitive about that. Go ahead.
It's Gordon, Gordon, Madonna, Madonna, middle initial G.
All right, you may proceed, Ms. Spengler.
Thank you. Detective Madonna, I know you recently testified. Just to remind us, you work for the Aurora Police Department as well as the Rocky Mountain Regional Center Forensic Laboratory, is that right?
Correct.
Okay. And are you a digital forensic examiner?
Yes.
And again, just as a reminder, do you extract, part of your job duty is extracting data from and analyzing computers, iPhones, iPods?
Yes.
Okay. And in this case, you actually processed and extracted data from Mr. Holmes' computers as well as his iPhone and his iPod, is that right?
Yes, myself and Detective Liker.
And just as a reminder, you've certainly been trained in computer forensics as well as removal procedures and how to process computers and iPhones, is that right?
Yes.
I just have a few some follow-up questions related to some of the information that was admitted as some prosecution exhibits and some questions that they had. And I want to start out with the iPhone. Your Honor, may I approach?
You may.
Okay, and I'm going to approach with what's been marked as Defense Exhibit 85. And I will show the prosecution as I approach. Now, do you recognize what I have handed you, which is labeled Defense Exhibit 85?
Yes, I do.
Okay. Is that a photograph, an accurate photograph of the iPhone that you processed?
Yes.
Okay. And is that, and also contained in that D85, is there the contacts that were taken out of the iPhone?
Yes.
Okay. And just to talk about that a little bit more in depth, when you extracted the data from the iPhone, some of the information that you got were the contacts within the iPhone. Can you just explain for the jury what are contacts?
Contacts are basically phone numbers, names, things like that. So when you have your phone and you want to call, for sake of argument, Mary, and you put in Mary's phone number or address, those are contacts.
And is that a fair representation of the contacts that you took from the phone or extracted from the iPhone?
Yes.
Judge, I'd move for admission of Defense Exhibit 85.
Is there any objection?
Just a brief white error, if I may, Judge.
All right, you over to you.
Just one question. Detective Madonna, are those the entirety of the contacts from the iPhone?
No.
Judge, with that clarification, I have no objection.
All right, without objection, D-TR-85 is admitted and may be published.
And if we could please put up Defense Exhibit is 3043, and that would be Defense Exhibit 85. And if we could call out the bottom portion or the bottom 2/3, right where it says contacts. Oh, that whole portion, yes. All right. Now, this is the first page of the contacts list, and next to column 2, or row 2, there's an A. And is an A significant for, that's how the phone number, the email addresses are entered into the phone, is that right?
Well, normally you have a name to go along with that.
Okay. And so on the, and underneath, excuse me, in that row, we can see that Lynn Fenton at ucdenver.edu is an email address that was listed as an A contact, is that right?
Yes.
Okay. And we can also see that that was deleted, is that right?
That is correct.
Okay. Now, there's some additional contacts. We've seen a contact for an apartment and for UCD, for Bobo and Chrissy. Can we move to the second page, please? And if we could call out the top portion, the top half of that page. And this is a continuation of the contacts? Is that right?
Yes.
Okay. And then moving on to row 8, we see a Feinstein listed, is that right?
Correct.
Okay. And then right under that, we see Fenton listed?
Yes.
Okay, and next to Fenton in row 9, we have a mobile number or phone number as well as a email address, is that right?
That's correct.
Okay, and the phone number was deleted, is that right?
That is correct.
Okay, and then but above that, for Feinstein, we have an email address as a listed contact in Mr. Holmes' iPhone, is that right?
Yes.
Okay, and that email address has not been deleted?
Correct.
Thank you. I don't have any further questions regarding the iPhone. I want to talk to you about the analysis or the work that you did on the cyber power computer.
Yes.
And a photograph of the cyber power computer has already been admitted as evidence. So I'd like to, if we could just take a look at that to get ourselves oriented. If we can look at, publish, Your Honor, what has already been admitted as a prosecution exhibit, and that's 3065.
Yes.
It's in our number 3065. And is that a photograph of the cyber power tower?
Yes, it is.
Okay. And when you extract data from a computer, were you able to determine, at least for the cyber power, the activity dates or the dates that this cyber power was active?
Yes.
Okay, and give us those dates, please. Sort of the time frame.
Trying to do it from memory, April 26, 2012 to, I want to say July 19th or 20th, somewhere in there.
Okay, and so what we know about the cyber power is that the operating system was installed on April 26, 2012?
Yes.
Okay, and we know that the last login time was July 19th of 2012?
That sounds correct, yes.
Okay, and so based on your understanding of the information in the record, this computer was used from April 26, 2012 through July 19th, 2012?
Yes.
Okay. And then the Lenovo tower, which we'll talk about in just a little bit, that last login time was April 25th, 2012.
That sounds about right.
Okay.
Yes.
Now, I want to talk about some of the exhibits that were already admitted by the prosecution but not shown yet. And they relate to the screenshots that were taken that reflect some of the web activity on the cyber power. Do you recall talking with the prosecution about that?
Yes.
Okay. If I may approach, Your Honor, the middle of the courtroom. And some of the information that was recovered from the cyber power involved some web activity, and we've heard about some of that web activity. And I know that related to some purchases and weapons. But also, the web activity also reflects some philosophical type searches and Wikipedia pages, and those are the ones that I'd like to talk about now. Do you recall finding those and taking screenshots of those web pages?
Yes, I recall seeing them.
Okay. And Your Honor, these have already been admitted as exhibits, and that's in People's 424A.
Okay,
And we'd ask now to publish some of these screenshots.
go ahead.
Okay. If we could please see 3077. This reflects a Bing search for free will, is that right?
Yes.
And if we could see 3078. And then a Wikipedia site for free will,
Yes.
3079. We then have a Bing search for determinism. Is that right? And 3080. Please, and and then a Wikipedia site for determinism.
Yes.
3081, please. And then we have a Wikipedia site for fractal, a math term.
Correct.
3082, please. Then we have a Bing search for probabilistic determinism,
Yes.
and then 3083. A Wikipedia entry for B.F. Skinner.
Yes.
And each of these screenshots are contained in People's 424B. Is that correct?
Yes.
I should say A, excuse me. 3084, please. We have a search for mechanistic determinism,
Yes.
and then 3085, please. And a Bing search for probabilistic determinism,
Yes.
and 3086, please. And then an entry for the Stanford Encyclopedia of Philosophy titled Probabilistic Causation.
Yes.
See 3087, please. We're back to a Bing search for fatalism.
Yes.
3088, please. And a Wikipedia entry for fatalism.
Yes.
3089, please. And then a Wikipedia entry for predictability.
Yes.
3090, please. A Bing search for fate.
Correct.
3091, please. Wikipedia entry for destiny.
Correct.
3092, please. Wikipedia entry for compatibilism.
Yes.
3093, please. And a Bing search for probabilistic determinism again.
Yes.
3094, please. And selectionistic determinism.
Yes.
3095, please. Causal determinism.
Yes.
3096, please. And back to Stanford Encyclopedia of Philosophy with the title Causal Determinism.
Correct.
3097, please. We have a search for free will mixed with determinism.
Yes.
3098, please. And then a Christian Clarity Review that is titled, in part, Mixing Free Will with Determinism Creates a Caste System.
Yes.
And 3099. And then this is a second page of Free Will Creating a Caste System in this Christian Clarity Review.
Yes.
So these are also, thank you, web searches and Wikipedia hits that were found on the cyberpower. And again, the time frame for the cyberpower is between April 26, 2012 and July 19th, 2012.
That is correct.
Okay. And there's no way to tell, not for any of this web activity that's been talked about over the weeks regarding the cyberpower and these particular screenshots, whether that web activity took place on April 26th or 27th, or whether it took place on July 19th.
Not from those screenshots, no.
Okay. And not related to that particular web activity coming out of that, related to the exhibits that People's 424.
I'm not sure I understand where you're coming from.
Okay. The Firefox session artifacts are not dated.
That is correct.
And all of People's 424 that we just talked about and that was introduced earlier are all Firefox session artifacts.
Yes.
Okay. And so that web activity, we don't know exactly when it took place, whether it was April 26th, July 19th, or somewhere in between.
Not from looking at those, no.
Also contained within that web activity was some WebMD.com activity, and that's also already been introduced, Your Honor, if I may publish.
Yes.
We've got 3070, please. And this is a WebMD symptom checker, is that right?
I see that, yes.
Okay. And then if we could see 3071. And this relates to the Bipolar Disorder Health Center and bipolar disorder question, what is it? Is that right?
I see that webpage too, but I do not recognize where they came from.
Okay. Is it not in, it's in People's 424 as well. I know that's a thick exhibit.
Is there a page number or approximation of where it would come from?
I don't think that there are page numbers I can approach if that would help.
Please. I think the reason why is you're not showing the whole screen on here. So.
And if you look at let me try it this way. If you look at People's 424A, or excuse me, B, does that contain the data that underlies the screenshots of 424B?
Yes, this would be the Firefox session store artifacts.
Okay, and if you look at the second page of that document, do you see the activity from WebMD?
Entry number 236, WebMD, yes.
Okay.
And 243.
Okay. And it's your understanding that the data that was introduced relates to the particular screenshots within that exhibit, even though I just can't put my finger on those 3 pages right now?
Yes, okay. And I think it's because of the screenshot that I'm looking at, it's not showing the entirety of it, so.
Okay. And if we could see 3072. And is that also, if you look back to that data, does that connect to the data on page 2 of People's 424? B.
$372.
I'm sorry, no, page 2 of People's 424B, reflecting that WebMD activity.
And entry number 243.
I believe so. There's only 2 entries there.
Yes.
Is that right? Okay. All right. And that connects to the WebMD Bipolar Disorder Health Center?
Yes.
Okay. Thank you. And we also see reflected within the web activity on the cyber power some activity on yugo.com. Is that right?
I don't recall specifically.
Okay.
If I see it.
Your Honor, if I may approach.
Yes.
Yes.
And does that refresh your recollection?
Yes.
Okay, and Your Honor, these have also already been introduced, these screenshots, in People's 424, and I would ask to publish a few of them.
From 424A again?
That would be 424A.
Okay, go ahead.
Thank you. I'm not going to show, we're not going to publish, I don't publish all of the Yugo screenshots, but you were able to identify them in the exhibit, is that right?
Yes.
Okay. We could see 3104, please. Okay. And this also reflects web activity in a screenshot that you took.
Yes.
And 3106. And this is an umbrella sword, also reflecting web activity that you took from the cyber tower.
Yes.
And 3103. This fighting fan, another activity, web activity that was taken from the cyber power.
Yes.
And 3139. And this ball and chain, more web activity from the cyber tower.
That is correct, yes.
Okay. And this web activity taking place sometime between, thank you, April 26th of 2012 and July 19th of 2012.
Yes.
And it could be as late as July 19th, 2012.
Correct.
Now, also on the cyber power, in the report, did you generate a report related to what was taken out of or found in the cyber power?
Yes, we did.
Okay. And within your reports that you generate, do you bookmark particular items that you think may be of interest to the person who submitted the request for the search of the electronic or computer in this instance?
Yes.
Okay. And in regards to the cyber power, did you and Detective Leiker bookmark depression in that report?
I recall that, yes.
Okay. And was that bookmark depression, or did you bookmark that word depression because depression and a URL related to an article on depression, publication number 4, was that found on the cyber power?
It was found on the cyber power, yes.
Okay. Meaning that URL was found on the cyber power.
Yes.
Okay. And that URL, if you take the entire URL and you put it into a browser, you, at least as of a few days ago, came back with a hit on the National Institute of Mental Health. Is that right?
Let me back up for a minute. Does everybody know what a URL is?
That's a good point. Why don't you tell us that?
Okay, URL stands for Universal Resource Locator. It's kind of like a post office address, so if you want to go to a particular site or something like that, you put that in your browser and it will take you to that web server for that particular page.
And would looking at the actual data related to that depression bookmark be helpful in describing what you mean?
Yes, it would.
Okay. Your Honor, may we publish, I don't need to admit, and let me show the witness, the data related to the depression bookmark?
Has that been admitted already?
It has not. I can move to admit it.
Is there any objection?
I need to see what it is.
And Ollie will just mark it, Your Honor, as Defense 86.
Okay. Ms. Spengler, is your request to show it so that the witness can explain what he's referring to
That's correct.
and can explain his testimony?
That's right.
All right. Is there any objection to him doing that?
I apologize, I was looking at this exhibit.
She's attempting to show it so that the witness can explain his testimony.
Understood, and I do not have an objection to DTR 86, Judge.
All right. It may be used as a demonstrative exhibit, so you may publish it.
And Your Honor, while I've gone ahead and marked it, I will just go ahead and show the district attorney a second page and approach the witness with what's now been marked as defense exhibit.
Okay,
I would object to the second page.
yes, are you intending to publish the second page as well?
Yes, Your Honor.
All right, would counsel please approach? All right, Ms. Spengler, you may proceed.
And Detective Madonna, I've handed you what's been marked as Defense Exhibit 86. Does that reflect both the data related to the depression bookmark found on the cyber tower, as well as a screenshot of a web page?
Yes, excuse me, yes, it does.
Okay. And since people have not objected, in order to just explain the next few questions that I have for you, if we could publish the first page of that exhibit, since I will be moving for admission of that, and the district attorney has no objection. And is that all right, Your Honor?
The first page, you don't have any objection to it?
Objection to the first page, I do have the objection to the second page.
All right, and you're moving its admission now?
Of the first page?
Okay, the
Yes.
first page is admitted, and you may publish it.
Thank you, Your Honor. 3062, please. And this is a D86. $30.62. I won't be able to publish it. I think I wrote a number down incorrectly. Let me ask you about the URL. Does that URL relate to the is that URL www.nimh?
That's the start of it, yes.
Okay. And if you put that URL into a browser, does the screenshot or that is attached to Defense Exhibit 86, is that what comes up?
If you put that into the browser, then if that page still exists, it'll come up.
Okay. And recently, did we put that URL into a browser, and is that is the second page of 86, is that what came up on the computer?
Recently, yes.
Okay. And what came up on the computer, does it connect back to the URL in that it is a screenshot from the National Institute of Mental Health?
Yes,
Okay. And it involves a publication related to depression?
that's the title of it, yes.
And I think we do now have the URL, so if we could put up 3062, or,
And given that additional foundation, are you moving into admission the second page also of D-TR-86?
I am, Your Honor.
All right, with that additional foundation, is there any objection?
I do still maintain my foundation objection, Judge.
All right, I think that goes to the weight of the evidence, not its admissibility. So the exhibit is now admitted in its entirety. That's D-TR-86, and it may be published.
Thank you. And if we could put up the first page. If we could call out the top of that page.
Bookmarks?
Actually, all of the written content, please. Great. And if we go down to the data at the bottom, do we see the URL that we were talking about all the way at the bottom, the last line?
Yes.
Okay, and that's the www dot, and then what that turns out to be National Institute for Mental Health?
I believe so, yes.
Okay, and then if we go down the URL, we go to we see the word publications and then depression as well?
Correct.
Okay, if we could then turn to page 2, which is 3146, please. And when we put that URL into the browser recently, this is what comes up.
Okay. As noted in previous testimony, this created bona fide access date for this file was 6/26 of 2012.
Was that June 26 of 2012?
Yes.
And that's for the reflected activity of this
Yes.
URL?
And as we mentioned with the previous screenshots were taken several days afterwards. This one was almost 3 years after the fact, so I can't say whether this is the exact web page that would have existed at that time, or I can't say that it wasn't.
Sure, sure. Thank you for that. That was my next question.
I'm sorry.
Oh, that's okay. Now I want to talk about the Lenovo computer. That's also a tower computer, correct?
I believe so, yes.
Okay. And the Lenovo was a computer with a last login date of April 25th, 2012, right?
I believe so, yes.
Okay. Judge, may I approach with defendants 87?
Yes.
I'll show the district.
Would counsel please approach for just a moment about scheduling? Actually, Ms. Spengler, let's just proceed and see if we can get it done.
Okay. Detective, do you recognize that photograph as a picture of the Lenovo Tower?
Yes.
Okay, one of Mr. Holmes's computers that you processed. And before we get to the documents behind that picture, first I wanted to ask you whether or not you recovered any web searches in the Lenovo.
Yes.
Okay. I want to just direct your attention to a search on February 26th or 25th of 2012. Out of the web history, did you find a search within the web, on the internet, for nervous breakdown?
We pretty much ran what's a tool, it's called an Internet Evidence Finder on that, just like the other computers and so forth. It recovered that type of data, yes.
Okay, and did I draw your attention earlier this week to that search, and you indicated that that reflected data that you recovered from the Lenovo Tower?
Yes.
And is that information that you recovered and also contained in the report contained in Defense Exhibit 87?
Some of it, yes.
Okay, just related to the nervous breakdown search, is that right?
That is correct.
And then also part of Defense 87 is a series of bookmarks, is that right?
Yes, you can call them bookmarks.
Okay, and those bookmarks are Firefox bookmarks, similar to the bookmarks that were introduced earlier as evidence found on the cyber power, correct?
Yes.
When I say similar, I don't mean similar in content, I just mean similar to, a bookmark is something, and you can correct me if I'm wrong, that if somebody is looking at a web page, they can bookmark that web page, and so it is identifiable either by an icon or a tab later on, is that right?
Yes, so that you can return to that page, yes.
Okay, and you recovered Firefox bookmarks both from the cyber power and the Lenovo?
Yes.
Okay, and the ones recovered from the Lenovo are attached to D87?
Yes.
Your Honor, I would move for admission of D87.
Any objection?
No objection.
Without objection, it is admitted and it may be published.
Okay, and if we could just publish the search that was done. And that would be 3156, please. And we can see here a string for Bing.com search and then see the term nervous breakdown, if we could call that out. And then the date, we're talking about February 27th of 2012. Is that in UTC time?
Yes.
Okay, and so in order to get to Colorado time, we would subtract 7 hours.
At that time, yes.
Okay. Thank you. And then finally, I wanted to just talk to you about some additional bookmarks, Firefox bookmarks that were recovered on the CyberPower that were not introduced earlier. And if I may approach with what's been marked as Defense Exhibit 88,
You may.
and I'll show the prosecution. Now, what I handed you, does that reflect all of the recovered Firefox web activity bookmarks on the CyberPower, or the computer that was used in April to July of 2012?
No, not all of them.
Okay, does it reflect many of them?
Quite a few, yes.
Okay, and does it reflect more than, include the ones submitted, or excuse me, introduced by the prosecution?
Now, you're trying to test my memory. I don't know quantitative-wise, but seems like there's a few more, yes.
Okay. And specifically, we see a bookmark, excuse me, I'd move for admission, Your Honor, of Defense Exhibit 89.
Any objection?
No objection.
All right, it is submitted.
And prior to May 10th, when we see the first bookmark on the People's Exhibit, do we see a bookmark on April 26th for getting started?
Yes,
Okay. And that relates to the computer activity?
yes,
Okay. And then do we see, close in time to that, a bookmark for Netflix?
yes.
And then a close in time, and what's that date?
For record number 3, Netflix is April 27th, 2012.
And then the next in time, what is that bookmark?
What is the number, item number that you're referring to?
I don't have the item numbers in front of me. Do you see a Hulu
Yes.
entry?
Okay.
And what is that date?
That would be April 28th, 2012.
Okay. And is it fair to say that in terms of the bookmarks that take place from May 10th through July 19th or July 14th, there are no bookmarks related to weapons, related to gear, that was found on the Lenovo computer that was used up to April of 2012.
I'm trying to remember the Lenovo. I believe that we didn't have any times past April, and I'm guessing 26 without seeing my report.
Right, right. And we've got, the bookmarks are now in evidence, but if you look at those bookmarks, those deal with real estate and school and baseball cards, is that right?
Some of them, yes.
Okay. Scholarships, interfolio, that type of thing.
Yes.
Okay. Your Honor, I have no further questions.
All right, cross-examination, Mr. Edson.
Good afternoon, Detective Madonna.
Good afternoon.
As part of your forensic data extraction, did you also extract data from a Toshiba laptop?
Yes, I did.
And that Toshiba laptop, you previously testified that that was one of the computers that was that you conducted the forensic analysis on, correct?
Yes.
That Toshiba laptop also had some web searches associated with it, is that correct?
That is correct.
Did you have an opportunity to review some of those web searches before you came in here to testify today?
Yes.
Yes. All right, the objection is overruled. Detective, unfortunately, I'm gonna have to ask you to return tomorrow if you're available. So, your subpoena is continued until tomorrow morning, okay? 8:40, thank you. All right, members of the jury, it's 5 till 5, so we're gonna go ahead and adjourn. There's a new judge being sworn in today, not sworn at. We wait till they take the bench before we start swearing at judges. But, all judges try to attend swearing in, and so I'm gonna try to attend the swearing in for the new judge, and that's at 5 o'clock, so I have 5 minutes to get there. So, I wanna make sure that you remember the admonishments. All of them apply tonight and overnight, and then, get some rest tonight, and I'll see you first thing tomorrow morning, all right? Thank you. Please be seated. The record should reflect the jury has exited the courtroom. Have a good evening, everyone. I'll see you tomorrow. The court will be in recess. Thank you.